I'll hear from you regarding the parenting plan. Ms. Dennis?
Yes, can you hear me?
Yes.
Sorry, I'm having technical problems this morning. Okay, so on the parenting plan in section 4, it lists reserved as far as any treatment, but the court did not order my client to receive treatment. It wasn't reserved, it just wasn't ordered.
Okay, let's just go by these one by one. Mr. Zandy?
Yes.
Yeah, and I think, and I believe it was. I think the court had, and I'm going to agree with counsel on some of this in principle, because I think some of this, there was no specific order made, but given the circumstances and our proposed parenting plan, I think we just need some clarification on some of these. My understanding of the evaluation and treatment is it was reserved as the court did find that Mr. Lemons had some prior struggles with alcohol abuse, and that you weren't making any determinations at that time, but nonetheless did recognize the fact that those services might need to be addressed in the future, which is I use the standard just reserved language under that paragraph. So again, I don't think we had specific order on that provision, but I think given the circumstances, that's reasonable and makes the most amount of sense.
Okay. I'm just going to simply write no ruling issued.
Okay.
Okay, Ms. Dennis?
The next section is in section 5. The court did not limit decision making. So my client's asking that school decisions should be joint. I mean, I believe the kids are homeschooled anyway. Mom is homeschooling, and he has no objection to that. But if they come up, they should be joint. And then on section 5B, the court did not reserve on that either. There were no limitations on the decision making, so that should be joint.
So I'm looking at 5A and it shows that healthcare and extracurricular are joint. And then are you saying that school and educational should also be joint? Okay, so it's out.
I apologize, Your Honor. Decision making should be joint because the court did not order sole decision making.
Yeah, in the proposed order I'm looking at, there's no limited or sole decision making.
For the school?
Well, it says reserved. The children are homeschooled by longstanding agreement of the parties. Then that's in the joint column. Is that what you're looking at also? Looks like the audio is not coming through again.
That I'll say that is reflected in the proposed order that we sent out a couple of weeks ago. And yes, I can confirm Ms. Dennis did request that just specified joint. This is the case in which the children have been homeschooled by my client for 7 or 8 years, by recollection. One of the kids is a senior in high school, so they're starting to get to that age. Again, court didn't give specific ruling on that, but given the fact that my client is essentially the provider when it comes to those issues, I think it probably makes sense, again, just to note the homeschooling provision as we've done so in that proposed order and reserve any language therefrom. Court is well aware of homeschooling mechanisms and how that kind of works and is in place. But again, I think that as opposed to sole or joint, we just say reserved any issues. Either party can come back. Just recognizing the fact that these kids have been homeschooled by my client for 7 or 8 years and are doing very well too, by the way.
Okay, thanks. Ms. Dennis?
I mean, I guess my issue is that the court didn't order them. I mean, I think that if decision making becomes an issue, it needs to be joint at this point in time. The court did not order sole decision making.
Okay. I think what I'm going to do as far as with the educational, the parties had engaged in a pattern or a practice of homeschooling their children for a significant period of time. And that may change here in the future with a change of the family structure. I'm not sure. But if I keep it reserved, at least in my mind, that preserves that pattern that had been established by the parents of homeschooling the children. What I don't want to have happen, is the one parent to say, "Hey, we're taking a clearly different path than we have in the past," because I don't think that's in the best interest of the children. Therefore, I'm going to leave it as reserved. That they're basically going to continue in homeschooling. Oh, looks like she's coming in. This Dennis is coming in on different. Okay, Miss Dennis, are you there?
Hold on. Yes, I did hear you. Yes.
Okay, great. So at this point, I'm going to leave it as presented, just reserved. Basically, I'm making a decision that they need to continue with homeschooling at this point. And unless there's a specific issue brought forward to change that. So right now, by leaving it reserved, my fear is that if it goes to joint, then one party may make a unilateral decision, say, this is what I want, and then it brings the issue to the forefront. And I don't think it's ripe or in the best interest of the children to make that big of a change right now.
Okay.
I'll leave that as is. Other concerns or objections to the parenting plan?
Yes, on section 8, we have on one day the transfer time is at 4 p.m. and then on the other day it's at 5 p.m. and my client would just like it to be at 4 p.m. on every day just to keep things consistent for everyone.
Okay, Mr. Zandy.
I don't think my client is going to dispute that too strongly, Judge. I would defer to the court's discretion on that one. The Friday at 5 to Sunday at 5 was the specific order given by the court, and then the Tuesday at 4 till 8 p.m. that same day was again the specific order of the court. If you want to change that, again, I don't think my client would have too much of an objection to that.
I'll make it 4 p.m. across the board. So Friday 4 p.m. to Sunday 4 p.m. and then Tuesday 4 to 8.
Okay, thank you.
Okay.
And
any others, Ms. Dennis?
yes, in the holiday schedule for Christmas Eve, they agree on the schedule, but my client would ask that it end at 10 p.m. because his family does a traditional like family gathering Christmas Eve that goes into the night. And
That's fine.
Okay.
Okay, I'll make that change, 10 p.m. Other concerns, Ms. Dennis?
Yes, the last one is in section 14, which is where we included the provision. The court has ordered that father not drink during his residential time. That part is fine, but then Mr. Zandy has inserted language about mom requesting a UA or a hair follicle test that was not ordered by the court. So I would just ask that anything after him not drinking during his time be struck because those provisions were not ordered or even raised.
Okay, thank you. Mr. Zandy?
And I recall it was raised. I recall it was ordered. Certainly, if we're going to say that dad is not to drink within 8 hours or during any visit, you need to be able to have some kind of a mechanism in place where you can ensure that he's not doing that. That would be the alcohol testing. And again, that's the standard language that we typically put in any parenting plan order. There's nothing that certainly impacts him outside of having to follow through with a UA if it's suspected that he's consuming alcohol or violating that provision. Again, I think that gives the provision the weight that he's not supposed to drink during his time with the kids, which certainly has been an issue in the past. So we're just asking you adopt the language as presented.
All right, thank you. I'm going to leave that language therein. I think it's important to have a mechanism to keep people honest on that particular provision. So I'll leave it as is. All right. Any other items related to the parenting plan, Ms. Dennis?
No, that's everything.
Great. So this is Ms. Amos Keita's motion related to contempt based on an order from July 25th of this year related to payment of a certain sum. So Ms. Amos Keita, I'll hear from you, and then I'll hear from Ms. Holder.
So I never received any payment after the set day, and I waited a little while and then still nothing. And so I just filed the motion for contempt.
Okay. All right. Thank you. Ms. Holder?
Your Honor, I do apologize for being late. I'd like to note that, number one, my notice of withdrawal I know is not effective. There was a hiccup in my firm. Ms. Amos Keita, we had sent her my notice of withdrawal effective August 20th. And so that was via email, which she accepted email service, but for some reason it never got filed with the court. So I do apologize. As such, I'm not representing Mr. Miller. And so I do not have any information as to why this was not paid.
So I looked at your withdrawal notice. I thought it said that you were withdrawing effective as of November 1.
Yes, that's correct. It was originally, I was supposed to have withdrawn, and I have an email sent to Ms. Amos Keita on August 8th saying my notice of withdrawal would be effective on August 20th. However, we had a paralegal leave our firm, and for some reason that paralegal never filed the notice of withdrawal with the court. So I do apologize, and it was not until my receptionist caught it that I was able to file it currently.
Okay. So as far as the way I interpret the pleadings is that you're still attorney of record and still representing Mr. Miller as of until November 3rd of 2023. So at this point, Mr. Miller, does he have a position?
I know that Mr. Miller is extremely tight on money. He is currently going through a divorce with his wife and is strapped on cash as he only is making his mortgage payment, is not having any income coming in from his wife. And my understanding is that he is just extremely apprehensive and nervous about what's going on. There's difficulty right now putting the house on the market due to the market conditions with interest rates. And so trying to get that all sorted out. He's basically been paycheck to paycheck, and that would, in my understanding, explain why he has not been able to pay Ms. Amosquita.
Okay. All right. Thank you. All right. So Ms. Amosquita, I'm going to hold off on making a finding of contempt. What I will do is reduce that $250 to a judgment and require that interest start accruing at 12%. So I'll draft a separate order and get that filed today or tomorrow. So that will happen. But I am denying the motion for contempt. But I will reduce the 250 into a judgment, and it'll accrue at 12% interest. Okay. So that'll conclude that for today. Any questions?
No,
Ms. Amosquita, did you have a question?
Yeah, what does the judgment mean?
The judgment means basically that when there's a judgment, so what I'm saying is that there was an order that said he has to pay it by such and such a date. He didn't do that. He filed the motion for contempt. I decided not to make a finding of contempt based on the representations of Ms. Folder, but reducing it to judgment allows you to pursue him legally, to put liens or to try to leverage bank accounts through legal means to get that money. So that basically a judgment means it gives you that's a tool that you can use to go after the money. Basically, you have to collect on that money through legal means. Mr. Agavino, Mr. Roberts is present. Okay. Ms. Winkles, I think she's back.
Yes, I haven't left yet, so that's good.
Oh, you haven't left. Okay. Good. Well, let me pull up my notes and the proposed orders there. So bear with me a moment. All right. I looked at all of those, and I wanted to just proceed with the proposed parenting plan provided by Ms. Winkles, and then provide some updates to that. So let me just tell you what I'm thinking, and then if you have any concerns, then I'll hear from you. I'm looking at page 3 of the proposed parenting plan. And this is on line. So I'm looking at page 3, line 4 through 5. And I'm proposing that I strike the first sentence of that paragraph, where I'm removing the line that starts consistent with the previous parenting plan from Oregon, and that order in this court on July 19, 2022, petitioner shall maintain sobriety if he's exercising his residential time with the children. So basically that everything from consistent to July 19, 2022, I was just going to remove that. I think it's just cleaner. It says petitioner shall maintain sobriety if he's exercising time with the kids.
No objection, Your Honor.
Mr. Roberts?
Fine.
And then on line 8, it reads, visitation shall take place within a structured and controlled environment. While the precise logistics are at the discretion of the supervisors, visits might extend beyond the typical supervisory premises. I'm striking the word might and may, because I think in my ruling I said specifically if the supervisor said it can go elsewhere, it can be in the community, what have you, then I granted that permission to the supervisor to make that adjustment. So
No objection, Your Honor.
struck that. Any concerns, Mr. Roberts, with that?
That whole provision, I think, is unnecessary. The supervisors should have discretion to control in a responsible way, which they will do, but I'd submit that to the court. And I have no objection to, if you want to edit it accordingly, that's fine.
Yeah, I tend to agree that there's discretion and trust given to the supervisors here. I wanted to beef that up a little bit, so I'm going to leave that included in that language there. Line 22 of that same page, of page 3. It says Mr. Agavino must commence domestic violence treatment. I wanted to add to that language, if such is indicated by the evaluator. Because it's based on the evaluation, because he has to get the domestic violence evaluation that's consistent with Washington Administrative Code and all that.
No objection.
That makes an assumption that he's going to be assessed at receiving treatment. So, Mr. Roberts.
And that was going to be my comment on that section.
Okay. Then I'm jumping to page 8, I believe, of the order, parenting plan order, where under line 23 says the duration of the call shall be determined by the children. I want to adjust that language a little bit to read the duration of the phone call shall be determined based on the age and developmental stage of each child. I think that gives a little bit of nod that, if the children, 2 minutes into the call say I'm done, probably not. But, to force a conversation well into, 50 minutes, 55 minutes, and it's just painful for a child at that particular age. I mean, just kind of a reasonability standard there. So just any concerns related to that?
No
No,
objection, Your Honor.
So let me just make that a quick adjustment. And then also on line 24, it reads, telephonic contact shall be scheduled with respect to the children's schedules and may be changed by the respondent. I had concerns about that. It just gave too much of a carte blanche for those telephone appointments to be changed kind of willy-nilly, if you will. So I wanted to change that to telephone contact shall be scheduled giving deference to the children's schedules and may not be changed unless agreed to by the parties or based on a medical emergency.
No objection.
that's fine.
Okay. And then I wanted to strike the language, if the time is to change, petitioner professional supervisor shall be notified the day prior to the change visitation by the maternal grandfather, Matthew Willett.
And no objection to that, because most likely I'd be the one changing it by calling the supervisor.
Yeah. Mr. Roberts, any initial reactions to that?
As long as mother's gonna be responsible for it, I don't want there to be a misunderstanding that, oh, grandpa didn't communicate what I meant to communicate. We had one issue with a late notice cancellation by mother, so we want her to be responsible if it's not done in time. If Miss Winkles is going to take it on, then he's acting as an agent of mother, and any failure to adequately inform will be understood to be mother's failure to adequately inform.
Okay. Kind of rethinking that a little bit. It says, if it says here, if the time is to change, petitioner professional supervisor shall be notified the day prior by Mr. Willett. Ultimately, I think what Mr. Roberts is saying, the ultimate responsibility is that it would be the mother's responsibility to notify them through the agent of Mr. Willett or father.
Your Honor, I think possibly just saying mother has a duty to notify the day before if it changes is adequate, because then either Mr. Willett or myself can notify if there's an issue. Obviously, there needs to be a good cause issue, medical issue, or something of that nature. But I think we all understand it's mother's, and maybe it can just stop at mother has a duty to notify.
Mr. Roberts?
I don't have a problem with that.
Okay, that sounds good. I'll include that there. I think those are the only items I was going to make mention of in that proposed order. Mr. Roberts, taking a look at that proposed order now, what do you have other concerns?
I do. Let's go through it line by line, and hopefully we can get on the same page here.
Okay.
Page 2, line 21 or so.
Okay.
The time states 4 to 6 p.m. or is agreed. I don't know if that's exactly what time that's going to be available for the supervisors. I don't think these parties are going to agree on much, and I would like it to be after school supervisors availability.
Supervisors what?
Availability.
Okay.
It's 3:30 or something, and mom says, I can't do that. I want 5:30, and the supervisor's not available. We don't have a visit. But the after school period of time should be left open. And I think they've already arranged some visits going out, but I'd really request the order have after school time be preserved, and whatever the supervisor has available in their schedule is going to happen unless the parties agree to change it.
Okay, thanks. Ms. Winkles?
And that's fine as long as it stays on that Monday or that Wednesday and Thursday. I don't think a half an hour here, half an hour there is a problem. It's kind of going through my office, so we're making sure that we just get these done.
Okay, so then, as it's written here, the father shall have visitation on the second Wednesday and Thursday of each month in the afternoon hours after school, not interfering with the children's schooling or school schedule.
That works for me.
That works for me.
Okay, let me just write that down then. The father shall have visitation on the second Wednesday.
Then the
Mr.
next, sorry, and then in the next paragraph, we kind of have a similar situation here. Obviously, I don't know if the last sentence starting with potential times is just surplusage and we can take it out. Really, it's the same mirroring language. So maybe the last sentence could be removed. I have a light objection to that, but I'm not firm on it. I'm just raising it.
Okay. Ms.
And
Winkles?
I have no issue. We put that in because Your Honor suggested it. You spoke about possibly 8 p.m. being too late, considering the ages of the children, but that 3:30 to 7:30 would be appropriate. You didn't want to go into the school hours, and at the same time, you were cognizant of 8 p.m. being too late for the children because then they'd have to get ready for bed and so forth.
And that's
Okay.
fair. And I just submit to the court. I just flagged it.
I'll strike the last sentence. All right, next.
The next page, top, the specific rules for supervision. I think that information is mostly in full unnecessary and surplusage. I think the supervisor is going to do that appropriately. So I would request that the first two lines be stricken, or two sections, excuse me.
I'm going to leave.
Um,
Normally I would agree with that, but in this particular case, I'm going to leave it in.
okay. The third paragraph, I know you struck the first sentence or part of that sentence.
Yeah.
With respect to the clean BAC, I understand that was in the prior order from a year and a half ago. Last visit, my client went across the street to a facility and there's a line there, etc. He has a backtrack device, BACTRACK. He's had that for, I believe, years. It's something that previously before, I think it was before the visits were supervised, he was using it. Mother and her father were okay with it. Ms. Winkles, as has expressed an objection to him using that. However, this is a device that he's been using for years. Mother previously agreed with it. My understanding is to calibrate it, it has to be sent to the agents, the company itself. I was researching that this morning before court, that you calibrate it by sending it back to the company. And he would request just being able to do that. Miss Fellows, who's supervising, has communicated to him that she's fine with that. She can supervise it in her office 5, 10, 15 minutes before the visit, and the results can be sent directly to mother. If mother's gonna demand that he go across the street to the professional facility, which may delay the visitation and costs additional money over the 150 or so he spent on this device, that he be responsible for those costs.
Thanks, Ms. Winkles.
Yes, Your Honor. I had the chance to play with one of those machines, and they're incredibly easy to change. Given that, and given the fact that we've already had expressed some changes to Discovery and some subpoenas that had to go out because of that, and due to the fact that this is an issue caused by dad, this is not mom getting dad drunk, this is dad getting dad drunk and going to the hospital for alcohol, beating up people for alcohol. It seems that
I object to the beating up. There's nothing in the record that he beat anybody up. I object to that.
The police records are there, but in any event, that's akin to asking my client to go get a hair follicle by going to Rite Aid, cutting her own hair and sending it in. It seems to me that dad should get there earlier. The BAC tests are very cheap. They're very inexpensive. This is a dad caused issue. The whole point of taking it through a professional place is so that it's not questioned and we know these children are completely safe. This is different than having him take one after the visit to make sure he was okay. That I could understand. Do the BAC that you bought off of eBay, absolutely fine. But this is to protect those two little young children beforehand. I'd ask that it stay in place. Otherwise, it is like taking an honor system UA.
What's the cost? Either party know what the cost?
Of the BAC at the place across the street?
Yes.
I believe it's $50 or 35 to 50. I can look, but I think I want to say $50. Do you know for sure, Mr. Roberts?
I'm asking my client. He's think he's not having audio issues, but I think he might be able to respond to me. And I will just flag, Your Honor, I don't know what device Miss Winkle specifically purchased, but the backtrack is a very specific device. It is. I read some studies on it from third party, and it's not your average, keychain eBay $30 piece of junk. It has to be calibrated through the device. It is $35. You just confirm each
Okay.
time.
And then you described it, Mr. Roberts, as him, if he were to use his backtrack device, Ms. Fellows would observe him do that. She would be in somewhat close proximity to him when he's doing that, and then she would see the results and then forward that to the mother.
I believe previously the results are you can send the results directly from the device, if I'm understanding correctly.
They're on your phone. You blow into it, you hold up your phone close, and the Bluetooth goes directly from the backtrack device to your phone where you have the program installed.
Sure.
Right. And Miss Fellows can meet him however many minutes before the visit, monitor it, watch him blow into the device, and then it gets sent off to everybody.
So I'm fine with the use of the backtrack device, simply because, number one, Miss Fellows will be there. She'll be observing, and she'll be a protective factor. If the machine's in any way tampered with or made to not be effective, she's going to be there with her own eyes and the like, and so she can be a protective factor. So
Can we have her install because part of it's that the program is what you change, not necessarily the little device. Can we have her install the program on her phone or on something? You can go to your app store and just download the app.
and then she would receive the information from the backtrack device.
That's right.
Okay, Mr. Roberts.
I don't have an issue with that.
Up to her, obviously.
Sure. I seems hard to hack into. My client's not a computer guy, but I'd submit to the court.
Okay, I think I'm fine with that. So then with regard to the language there on the third bullet point, add language, delete language, supplant.
I would say father's track device is sufficient if monitored by the supervisor.
And that's fine for us. And I can email the supervisor and see if she's be willing to put it on her phone. If she's not, then we'll just have Dad there with his phone.
And the spelling, by the way, is capital BAC, all three capitalized, and lowercase track, common spelling, all one word.
Ah, good. I'm glad that you told me that.
I had to look it up.
Okay, so I said father's backtrack device shall be used while monitored by the supervisor. Okay, next item.
The line 10 or so on the same page, the video recording. Last time when we continued this, so Miss Winkles had more time to respond, court did, as a sort of Band-Aid measure, have the video recording on the understanding, as I understood it, that Miss Winkles was going to file a motion about the importance of a video recording. As I mentioned at that hearing, this was not something that was discussed at the actual motion hearing itself. The video recording is an artificial addition to the visitation above a supervisor that is going to constrain the natural interactions between the parties. My clients indicated to me that his daughter asked him, "What's that camera doing here?" So without a motion that Ms. Winkles has filed about the necessity of this or the importance of this, this just seems like an addition to the order that was never litigated, and there's not a basis for it at this time. There's going to be a supervisor there that ensures everything is okay, and this is unnecessary language that was not discussed or ruled on.
And he does have a point, Your Honor. I only got the video visitation a few days ago. And that's what the whole point of me wanting to file a motion. I needed to see something, which is why Your Honor allowed it for that one time, to see if it was actually useful. I only got it two days ago. I'd ask that we don't need to record right now, but I'd ask that we kind of reserve on that. And I can get a motion filed once I reviewed it. It came in like 7 different files. I'm sure Mr. Roberts got it as well. It was quite difficult I think there were 14 of them. They're little pieces. It may not be useful, but I'd like the opportunity to review all of it and then ask the court, to continue it if it's useful. If it's not useful, it's not useful.
I simply put off to the right side of that, reserved.
Perfect.
Fine. That's fine with me.
That's fine.
Okay.
The next section, more of a question on this than an objection. Same page, line 19, with respect to a comprehensive search by everyone. And I actually appreciate that Ms. Winkles put in comprehensive search by all parties. My client already tried to get a Washington licensed evaluator to jump in on this, talked to Olivia Lovely, talked to Miss Corey. So I'm not saying we should not search. I know the court made the ruling. I'm not trying to relitigate it. I just want to know if we don't agree, because it may be that Miss Winkles and Miss Corey say, we've searched, we can't find it, got to do the California thing. But I'd like some clarity at this point so we don't have friction ahead of what that comprehensive search is going to look like, what my client has to do to cover his bases so that we don't get into problem down the road 6 months from now and we can't find anyone and we're arguing and we have to come back to court.
Thanks.
And Your Honor, we need probably, I think I may have found somebody, just putting that out there, but I'm not sure. We haven't talked to them yet. They do have the correct licenses. Can we have 30 days? And then if we haven't found anyone, we can come back on a review and we just choose what happens.
Okay. I think I'm going to replace the word comprehensive with reasonable. Meaning not every single stone needs to be overturned. You know, if there's a log of, you know, I've identified 7 potential therapists, and this is what each of one of them say, and they all say blah, 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 blah. You know, that's pretty reasonable. And if the other party says, well, look, I found 45, then that's probably going to tell me the 7's not very reasonable. So if both parties are looking at it, I think if we leave the term reasonable in there, I think we'll be able to find someone, hopefully, or reasonable efforts we've sought, and they'll give us information if there are some.
Great. I have a lead as well. It may be the same one Miss Winkles has, but we'll try to make that work.
Great.
Moving on to the next page, line 4, 5, whatever, last bullet point. I think that's an unnecessary provision that doesn't have anything to do with the court order. That's not be stricken. Starting with the court emphasizes the crucial nature.
Thanks.
Yes, I thought it was very important that Your Honor addressed that, given the I guess the Bar Association's new comments on domestic violence and on intervention and on dynamics of power, because that was part of the problem. I'm hoping that whoever does the evaluation sees this and can evaluate Mr. Agavino basically with this viewpoint of domestic violence in mind. It's not just these two parties that don't get along and it happens, that it is a dynamic of power and it's inherent in the relationship and that needs to be fixed through intervention. So I thought Your Honor was did a very necessary thing by including this here, because it is a signposting to whoever is chosen to do that evaluation, considering they are going to get this order.
Thanks. You know, I think the order, this is an order that's going to give guidance to the parties so they'll know what needs to be done, what doesn't need to be done. And it says, you know, he needs to participate in, if the treatment is recommended, he needs to be doing it at least 3 months, and has to be actively involved in the treatment prior to any expansion. While I agree, you know, that language is something I probably said or made reference to. I think as far as the order itself, I'll leave it out and just say this is what the parties need to do. So I'll strike the 4, 5 lines.
Okay. Then the next section, line 7, 8. The initial domestic violence evaluation, I don't have an issue with him providing that and filing it with the court, but compliance reports on a monthly basis, he's going to be signing on our ROIs. So I think that mother should update, and she has the ability to get those on a monthly basis. I'm not sure they're going to have them on a monthly basis, but if mother wants them, I would object to father having to provide ongoing monthly paperwork when she can obtain it in a 3-minute email.
I'm going to leave that provision in.
Okay. The next section, lines 10 through 12, if you will. If he fails to seek treatment for 3 months or longer, the respondent may come back to court for a more restrictive plan. That was never discussed at the prior hearing. It was never ruled upon. If the visitation is going well, I'm a little strained to understand why mother would even want that, given the fact that the children are improving their relationship with father, and I'd ask that be stricken.
Thank you. Ms. Winkles.
It all comes down to, again, intervention, again, why the other one was in there. Intervention is crucial to change a domestic violence perpetrator. And the fact is while he's in a supervised setting, having contact with the children, if he does nothing to fix this, which he hasn't done, this was ordered by the Oregon court, this was ordered already by the Washington court, dad has done nothing. The fact is then becomes a danger to the children, especially as their bond grows and there's more power there. If dad doesn't learn how to address that power, then we are putting these children at risk of future danger, especially if the visits start becoming unsupervised. And so this is kind of a signposting to dad. If you do nothing like you've done for the last 2 years, then there is going to be a change. And it says mother may. Doesn't say that the visits are going to stop. Doesn't say anything about that. It says that she can petition the court for a more restrictive plan. And that's kind of a penalty to dad. And it's also kind of a protective measure for the children in the future if dad does nothing to change his prior behavior.
Your Honor, it took him 10 months or so to even find an evaluator in California that could do this. So, and mother knows this. I'm not sure Miss Winkles knows it because she's new. I'm not, but this is something that we've been dealing with for a year and a half. And he was trying to find an evaluator. Miss Lovely was an assistant to him. Miss Forey was an assistant to him, and he couldn't find one within 3 months. This is a completely unreasonable term that only seeks to punish him because mother doesn't want him to have time with the kids. If the visits are going well and are supervised, there's no reason why it should be revisited.
I'd be willing to change it to 9 months. I just want, but the question is because the Oregon order has been in there since 2017, just not a redo of what happened in Oregon.
The Oregon order was contingent on him being on probation, which he was no longer on. So you can't have a court-ordered probation referral when you're not on probation anymore, Your Honor. We talked about this at the last hearing, and I think the court understood that and agreed.
I guess the concern I have is, when it says, however, if he fails to seek treatment for a period of 3 months or longer, this order gets signed today, 3 months, there's still efforts to maybe locate somebody. There's some concerns that at that point that there could be a motion brought to limit visitation or what have you. There's also the separate concern that Mr. Agavino does not engage, drags his feet, and these children are his forever, right? There's a desire that if there's recommended treatment that he engage in that treatment. So it needs to be adjusted a little bit. I'm thinking if it reads, however, if he fails to seek treatment for a period of 3 months or longer after a proper evaluator or treatment provider has been identified, the respondent may motion the court, something along those lines.
No objection.
So once it's been identified, once it's basically that this is the person we're going to go with, it sounds like the parties have some leads on who that therapist might be, or evaluator, pardon me. However, if he fails to seek treatment for a period of 3 months or longer, once an evaluator has been identified, does that solve it, or?
It's really once treatment has been ordered.
Okay.
But I'm okay with what's treatment has been ordered language. However, I think we need an additional condition that is once treatment's been ordered and the first appointment or start date has been identified. But if he's been ordered to do treatment and they don't have the first opening for 4 months, I think that's unlikely, but honestly. However, the order needs to provide for the inherent delays that are no fault of his own.
Sure.
Well, and that's why it said it fails to seek treatment. So that was one of the reasons that using that seek treatment language is because he doesn't actually have to be in treatment necessarily, because God knows how long that's going to take, but he has to actually do an affirmative action, get there, seeking treatment, making an appointment, doing something affirmative to show, he's been ordered treatment. And guess what? He has got treatment lined up. It's this person. That's great. As long as he lines that person up within 3 months and doesn't sit and do nothing, we're happy with that.
That's within 3 months 3 months of treatment being recommended. I think that's going to be fine.
Yeah.
Yeah, I think so. I'm going to include here. However, if petitioner fails to seek treatment for a period of 3 months or longer, once treatment has been recommended, the respondent may motion the court.
Perfect.
I think that's workable.
Okay, we'll leave that in there like that. Okay, thank you. Next one.
Okay. We're getting there.
Yeah.
Page 8, going back to section 14, section D, line 21. I'm not sure if the calls are at 3 p.m., the third line, really at 22. I just wanted to flag that because it could be after school.
I didn't know. I didn't know either. It seems like
maybe if I just put strike at 3 p.m. in the hours following school or something?
That'll be fine. It's
That'd be
currently
fine.
at 2:15. So, and my client's fine keeping it that way. But also, if the supervisor has an issue and it needs to go to 3:15 because they changed their scheduling, I mean, as long as it says after school, I think we're going to be okay.
We're fine with that.
Okay. So I struck at 3 p.m. and added in the hours following school.
I think you addressed my other concerns in that paragraph. Next page, page 9, line 3.5, 4.5. The language should be within 3 days. I know that she's done them, but I still think the order should be clear that it's within 3 days.
She
It's really
did
within three.
take, she did take them. We did have we did have trouble finding somebody. I put 9 to 10 drugs. So it appears nobody does a 10 drug in Longview. You can get a 9 drug or a 17 drug, $250 difference. And then you can't get an alcohol hair ETG in Longview. You have to go to Vancouver. So my concern with putting the 3 days is mom took the alcohol UA ETG in Longview, also did the drug hair or urine in Longview, and then had to go, I think it might have been 4 days. We found a place after searching a lot. She went to Vancouver and took an alcohol hair test. So you'll see a whole load of drug tests. That's purely because up here they do not do alcohol hair. There used to be a place that did. It appears that it's no longer in existence. So I'd ask that we leave it as it is right now because she's already done those. One may be 4 days though, and that's just because we did. I even emailed Mr. Roberts and said, if you know of anywhere, please let us know because we can't find a place.
Mr. Roberts, I'm inclined not to make any change there. She's already complied with that provision.
I think that's fine for now.
Okay. All right. So
We can
I won't
address
make any
that.
changes then.
That's everything on the parenting plan. I know we both also submitted different temporary orders. Was the court inclined to go with one versus the other?
I'm
don't
inclined to follow and use Ms. Winkles.
Okay. My similar objection to some of the pieces in the parenting plan that we discussed, the specific findings are very detailed and broad. I don't need to go through them in detail, I don't think, but the court made a lot of comments at the last hearing that I didn't take as specific findings necessarily, but they've sort of all been wrapped up into this order. And therefore, I object to the form of it with respect to section 2.
Yeah, I mean, basically, the important part, I think, here is the conclusion that, the evaluation that was taken, it just didn't meet mustard. It wasn't good enough. So taking out paragraph 2 doesn't really change much because we're saying he has to get a new one that's up to speed. So I'm fine striking 2.
And everything else is fine. I think I've made all my objections. So if the court wants to enter everything as is, we can go from there.
Okay, great. Thank you both very much. I appreciate your help and
No, I have
assistance.
no objections. to
Thank
that.
you, Your Honor.
Okay,
Thank
great,
you both. I appreciate it.
All right, this is
Have a
a
good day.
motion brought by Ms. Winkles related to the child on the phone. Ms. Winkles?
Yes, Your Honor. I've been asked to represent the child through court appointment, which would be all well and good, except I have never been able to get a hold of her when I'm trying to get a hold of her. It appears that she did have a phone, that mom took the phone, and understanding that obviously child did quite a lot to deserve the phone to be gone. However, I can't communicate with her. So I've spoken to her once for a period of about 15 minutes. I've never been able to get a hold of her again. It seems to be a miscommunication or not sure why, but none of my calls are returned or my office will leave a message. We will get a call back after business hours or before business hours. So my hours, which are posted on the outside of my building, also posted online, are 8:30 till noon. And then from 1 to 5, Monday through Thursday. On Friday, we close at 3:30. Those are posted everywhere. It appears that the only time I'm called back is either before we start work, during the lunch hour, or after work. All I want to do is be able to speak to my client. I wasn't even able to speak to her about this motion. I did tell her I was going to file it. I've never been able to get her to sign anything because I can't communicate with her. So if mom doesn't want to let her have the phone because she's been punished, then I ask for, during the pendency of litigation, that client be brought to my office at least once every 2 weeks for half an hour communication with her. It's very difficult when the only time I have been able to speak to her, it's been on mother's phone. And so that kind of concerns me, that we're using, this child is not against mother, not against father, but the fact that she was appointed counsel says something. And she is close to the age of majority. So I do ask that we find a way for me to communicate with her alone, to where she's not using anything that is belongs to another, that can be monitored, that she's not only able to communicate when a parent says, you know what, she likes me right now, so I'm going to let her communicate, or anything of that nature, but it's actually the child gets to say what she really feels. And that can only happen with the utmost respect for that child's privacy. So I put this motion in asking for her phone, but I know that that's kind of going against, obviously, what the parent is able to do with behavioral modification. So I ask that Your Honor maybe come up with a way to where I can speak to her at least every 2 weeks. If something comes up that's very important, I'd ask that she be allowed to call me maybe from school, but in any event, needs something so I can communicate. Otherwise, I can't really do anything for her.
Thank you. Ms. Gilmore.
Yes, I represent Petitioner Kevin Cahill. We do not have any objection to the motion. I already signed the proposed order presented by Ms. Winkles. I think it's just important to note for the record, I didn't provide any responsive pleadings because, again, we agree. But it's important to note the fact that my client hasn't had any contact with the child, so he hasn't participated in restraining the child's ability to have communication with Ms. Winkles. So I did want to make that note for the record, and just generally the fact that this just chaos going on in mother's home is frankly the reason that we requested this attorney. So my client has concerns about, frankly, both pleadings presented by Ms. Winkles as well as Ms. Jackson. So we do ask the court grant the motion, provide the relief to ensure that this child has some sort of representation, again, because the declaration is relatively concerning. This child is failing out of school and the like, and it needs to be addressed.
Thank you. Ms. Jackson.
I actually have a couple of questions, if I can ask Miss Winkles or even the court directly. I am just wondering, is Miss Winkles the same Erin Winkles that was previously associated with Wallstead Marching?
So can you just focus on the motion at this point in time and just tell me your position?
Yeah, I kind of am. I am a little concerned that if she is the same Erin Winkles, she actually represented Mr. Cahill in this matter when he was represented by Wallstead Marching. She appeared in court for him several times, so I have a little bit of concern about that and how she's then viewing me. So I guess that's my reason for that question. As far as Elizabeth's grades, Elizabeth is currently passing all of her classes. She had her phone returned to her almost 2 weeks ago because she had made changes to her grades and her behavior. The phone was returned to her. I also provided Miss Winkle's office with our home phone number, which is also a way for her to contact Elizabeth on the 16th of October. They have not reached out to that phone number at all. Elizabeth is home alone every day after school, 4 days a week. She's only has somebody home every other Tuesday and every other Thursday with her, so she could be reached that way as well. There's been no attempt to even make contact with her at either of those numbers in the last 2 weeks. So I guess those are my concerns. Also, she says that she only spoke with Elizabeth for 15 minutes, but I show conversation that she had with Elizabeth for 1 hour and 4 minutes and 52 seconds on September 22nd, which was the date of her appointment. So I'm unsure how she only spoke with Elizabeth, but there was over an hour conversation had.
Okay. Thank you. One quick question for you, Ms. Jackson. As far as in your pleading, you indicated that, you have particular appointments, lashes, whatever, add that, making an additional appointment with Ms. Winkles for your daughter wouldn't be an issue. Did I interpret your pleading correctly?
I never had an issue. Actually, I was the one that reached out to Miss Winkle's office on August 9th when I received paperwork saying she was the one appointed to Elizabeth. I asked if an appointment needed to be scheduled. Her assistant told me no, she was on vacation or something at that time. I did ask that if appointments need scheduled, if they could please just call me because Elizabeth does not drive yet, and that I'd be more than willing to make an appointment and bring her there. Nobody called me to schedule any appointments. At our last court hearing,
I think you answered my question. Thank you. I appreciate that. So my impression was correct. Thank you. All right, Ms. Winkles?
Yes, I have never represented Mr. Cahill. It is possible that under Walstead Merching that he was represented by Nicole Tideman or by Chelsea Baldwin, and maybe I came on to set over a hearing. I have no facts of this case whatsoever. He was not one of my clients. He may have been Walstead Merchings. I predominantly did real estate there, and construction law. With regards to callbacks, I personally have made callbacks. The appointment may have been longer than 15 minutes. I couldn't remember, to be honest. It was so long ago. It is concerning that mother knows exactly the time, and this is part of the issue. Mother knows exactly the time that I spoke to the child. This is supposed to be something that's completely between me and the child. It has nothing to do with the parents, Mr. Cahill or mom. And again, my client is obviously is happier where she's at. Well, according to our last conversation, is happier where she's at now than she was in the past. There are issues, but I'm not on either side of the parent. I'm on the child's side. It still remains the same. The fact that the child's had the phone for the last 2 weeks is a little concerning that she hasn't called me. And if child doesn't want to be represented, I need to know that as well. It's completely up to the child. I still ask for the same thing. I think even bringing her in some point next week for half an hour talk, if child doesn't want representation, if child's happy now, great. These are teenagers, so they vacillate. But still, I do need to speak to her. I can't represent somebody that I don't know what they want.
Okay, great, thank you. Well, let's do this. Let's just make it 2 times per month that Ms. Winkles has opportunity to meet with her client. I'll ask if Ms. Jackson, if you could reach out to Ms. Winkles and set up an appointment in the next week or so, and then they could meet. And if there's need for continuing representation, great. Then we'll be meeting for 2 times per month.
Yes, so that's fine.
Okay, great. All right. As far as an order to that effect, I'll do I have an order for relief submitted by Ms. Winkles. Say the child Elizabeth shall have 2 appointments per month with her attorney in person. All right, I signed that, and I'll take care of the hearing today. Thank you.
All right. Thank you, Your Honor.
Thank you.
Cause
Your Honor, I
number
do believe that's my last
133206-4.
matter. Did you want to return to
Ms.
clerk?
McLean is present. She represents Tristan Peterson. And I see Ms. Peterson is on the line with us also. And then is Levi Bondurant here today? Mr. Bondurant, I see that you're on the call and just want to make sure that you can hear me. Mr. Bondurant? Mr. Bondurant, if you are speaking, I see that you're muted. So make sure you're press the button so you can unmute.
Yes, Your Honor, I'm here. I apologize. I was having trouble with Zoom.
Okay, all right. So Mr. Bondurant is present. All parties are here. This is on a motion brought by Ms. Peterson. And let me just pull up my notes a moment. So this is an issue related to an adequate cause to modify the parenting plan. And one quick question before we get started, question for Ms. McLean. Looks like service upon Mr. Bondurant was effectuated for today's hearing on October 12th. And
That's correct.
how does that square with the 20-day rule?
Technically, it doesn't. So Mr. Bondurant had not requested, he's been in communication with me. He did not request a set over. So we're here today based on the notice that he was served.
Okay. All right. So, Mr. Bondurant, did you file anything in response to the issues that were raised by Ms. Peterson?
No, Your Honor, but I mean, the order that was served to me or the paperwork, it was extensive. I was actually hoping to potentially get a continuance anyways, contingent with the fact that I already have a mental health evaluation that I feel like this court could use in another case that Ms. McLean is actually asking for also.
Okay.
And
no, go ahead and finish what you were going to say.
I actually have another child custody case that's running parallel to this, and I did submit to a mental health evaluation in that court hearing. It's something that Ms. McLean is asking for, and I feel like it could be super beneficial to me moving forward. And as far as the amount of time, I'm not an attorney, so I don't know what my allotted times are for going through this paperwork or filing the paperwork in response to hers. So I was hoping to get a continuance anyways based off that information.
Okay. Ms. McLean, any comments?
My only comments would be that certainly this is not Mr. Bondurant's first time being in court. If you go back and look at the history of this case, there have been several different court hearings involving this matter. Also, if you take a look at the summons as well as the order to show cause that were served upon him, there is identification of what he needs to do as far as following up and making sure that items are filed with the court and provided to me. So if the court is inclined to set this matter over, I guess the question is when is he going to provide his documentation? My other comment would be that obviously my concern is that any mental health evaluation that he's completing pursuant to my client's motion, we would ask that that include collateral input from her, given the substantive or substantial information that she has as to his mental health history. And then I would want an opportunity to obviously put together reply documentation for the court.
Your Honor, can I speak?
Ms. Rondo, just following up on that, as far as your time frame, what's your time frame? When do you plan to file responsive documents to the issues that Ms. Peterson raised in her pleadings?
Well, the only real issue that I'm like.
I kind of need
2 weeks.
2 weeks, you say?
Yes, Your Honor.
So you would file that information in 2 weeks from today. Ms. McLean would have it, and then she and her client would have opportunity to review it, and they'd have opportunity to reply or send in documentations to the court to what their position is to what you said. And then that usually means that we would set a hearing basically 2 weeks after that, basically, so we could hear what everybody has to say on that. So it'd roughly be 4 weeks.
Okay, Your Honor. I mean, I don't know if that's okay with you guys, and that works for me. Like I also said, and I know she mentioned that she, in her order, that she did ask for that there be input from Mrs. Peterson. However, there has been a very broken line of communication for over 10 years. She has absolutely zero knowledge as to my mental health. I don't feel that that's relevant in any terms at all.
Okay, thanks. Yeah. The mental health piece, just like medical information, my experience has been that when evaluators are looking at that, having a long history, although it may be somewhat dated, provides a better, clearer picture for the evaluator. A person may not have up-to-date information about a person. However, if they have historical information, the evaluator can take that into consideration, give it what weight it's due. So I think that is an important consideration. So I would require that if you are going to get a mental health evaluation, which I think is that's great that you're being proactive like that, that Ms. Peterson would have opportunity to provide collateral input. So
Your Honor,
I would
sorry, I
require
apologize.
that. Go ahead.
My issue there being is that the person who would have the most knowledge or input and I know Mrs. Peterson and my wife are in conversations. The same input would be provided to the evaluator based off of my wife's information, which is being input in another case. I think that if I put in several different inputs, it's going to create a very biased opinion. From the beginning, I'm already complying with the courts in terms of where and who and what their credentials are required. I feel like that in order for me to have a fair assessment, that the input of one and the most relevant spouses or romantic, whatever you want to call it, it would be necessary.
Yeah, I think I hear what you're saying is that you're concerned if that there's maybe collusion between Ms. Peterson and your wife related to any evaluation. Evaluators are pretty savvy folks, has been my experience. We trust them to take information, weigh it, check sources and motivations why they may be sharing that information. And they may discount a lot of it because the motivations in their view, may be deemed not credible, or they may have an axe to grind or what have you. But I think with this mental health evaluation, I think especially with medical issues, a longer view often gives evaluators more information, and more information generally leads to a more precise evaluation. So notwithstanding the objection, I will require that any mental health evaluation, Ms. Peterson would have opportunity to provide a collateral input to the evaluator. So we will come back in 4 weeks. And then Mr. Bondurant, you indicated that you would be having all your documents filed in 2 weeks. So that means by November, let's see, what date would that be? November 14th, you would have all your documents filed with the court and a copy provided to Ms. McLean on that same date, if not before. And then we would be back here on the 28th of November.
Your Honor, is Mrs. McLean requiring or asking for a guardian ad litem in this particular case? Because the paperwork that I did get, there's already a guardian ad litem in another court case, and can that be utilizable?
Ms. McLean is asking for a guardian ad litem to be appointed.
Can we utilize the same guardian ad litem as far as in terms of saving from a financial? So we have to do separate guardian ad litems.
These will be things that we'll talk about when we come back to court on November 28th. They're important issues, but yeah, we can talk about them on November 28th.
Okay,
Your Honor,
thank you.
I'm sorry. The only clarifying information that I need is that Mr. Bondurant is referring to an individual and credentials as far as this mental health provider. I don't know to whom he's referring or which court has ordered him to do that. I'm assuming maybe in the matter involving his wife, Chelsea, but I don't know who the individual is. So I would need to know that information.
Just who the evaluator is.
Yeah.
Yeah. Mr. Bondurant, can you, that would be important information in order for Ms. Peterson to give that collateral input to that evaluator. Do you have the name of that individual?
It is through Core Health. I actually can provide that information. I don't actually have a specific name. The day that it was asked of me if I would get a mental health evaluation. I felt that it was in the best interest of the child and myself to provide that for the courts. And the same day I did schedule an appointment. However, I don't know the name of the specific person who's going to be doing it. I know that it met the credential requirements, and it's on the 6th of November.
Okay. Do you think you could contact that individual today, find out their individual's name, and then notify Ms. McLean by close of business today?
Yes. Would it be okay if I send you that information via email?
Absolutely. And I would just note that I've had other cases involved where Core Health has been requested to do mental health evaluations with collateral input, and they've declined to do that. So I'm just providing that information up front. We've actually had to seek other providers outside of Core Health.
Interesting. Okay.
I don't have any information in regards to that. So is that something that I have to contact Core Health and ask them if that's something that they're willing to do in this particular case? Or is there paperwork?
Yeah, I think that would be important. I mean, you as the client, you could certainly make your wishes known, like, hey, I'm the client here, and I would like to have Ms. Peterson provide collateral input. Not that that's what you're wanting, but that's what the court has ordered. So yeah, I think if you make that known to them, that would be really important. And please do that, and then let Ms. McLean know who that individual is.
Okay, and do I need to place in an ROI for Ms. McLean as well?
It would be for Ms. Peterson.
Okay, so the ROI would be Mrs. Peterson then.
Right.
She would be providing the collateral input. And the prior provider that I'm aware of was Ms. Ludvigson, Ludvikson. She was unwilling to do that. Just so
okay.
This is what I do know is that this is a male evaluator.
Okay.
All right. Great.
Thank you.
Okay, great. So we'll see everybody on the 28th, and Mr. Bondurant, you'll have your pleadings filed and copies given to Ms. McLean by the 14th, and then by today, close of business, you'll provide that name to Ms. McLean.
I am
Absolutely,
present,
Your Honor.
Judge.
Thank you.
Okay, welcome, Mr. Bondurant. Thank you all. And is Shariah
Thank you.
Nilsson on the line? Shariah Nilsson.
Yes, I am present, Your Honor.
Okay, welcome to you also, Ms. Nilsson. All right. Bear with me one moment while I pull up my notes. This is a motion brought by Mr. Daly for parenting plan and child support issues. And then Ms. Nilsson, it looks like you filed some responsive declarations and pleadings. Did you provide copies of those to Mr. Brungart?
I have sent them to him. I don't know if he got them or not. I have not received any notification if he got them.
Okay, Mr. Brungart, did you receive the declarations that Ms. Nilsson supplied to the court?
Yes, Judge Evans.
Okay, great, thank you. All right, I'll hear from Mr. Brungart, and then we'll hear from Ms. Nielsen, please. Mr. Brungart.
Thank you. Judge, you reviewed our initial pleadings. Subsequent to that, we had my client file a supplemental, and I'm just going to primarily now respond to the materials that have been supplied to the court by the respondent mother. Want the court to realize that the respondent mother supplied some information regarding an incident that was investigated by the Longview Police Department. I can say to the court that that matter has been evaluated by the Caldas County Prosecutor's Office. It was subsequently referred to the Longview Prosecutor's Office. Both of those jurisdictions declined to bring any charges. I would imagine that it was due in part to the fact that if there was an assault in this case, it was de minimis. As Your Honor probably recalls, I'm certain, read the report. The worst allegation in that report is that, in fact, my client allegedly was storing things and allegedly hit her ankle with a nanny gate. There was also some troubling allegations that my client was armed with a weapon on that particular day, that in fact he was either threatening himself and or perhaps the respondent, but more importantly, after a very thorough investigation and the police report substantiate, my client denied having a gun. Any guns found that day, Your Honor, were in a safe, and the basis of all of this brings forth the fact that the respondent mother believes that before we move on in this particular case, that there would be a domestic violence evaluation done and that there be an alcohol evaluation done. Judge, I'm not going to mince words. These two people are not living together, and it's very obvious why. There's obviously a great amount of ill will, at least directed from the respondent mother to my client, and her concerns are two. Her concerns, even though important, there is no allegation in this matter that there's ever been any domestic violence, especially involving the child. Even though the respondent mother in this case has submitted declarations that my client verbally demeaned her, that is supplied by the mother, it is supplied by the sister, but the record before the court is that it's absolutely devoid of any acts of domestic violence. Number two, regarding the alcohol, again, those are simply the reports of the respondent mother, and that concern can certainly be met in a parenting plan. The court can obviously order that my client during any period of visitation does not consume alcohol, and if in fact the respondent mother believes that she has a reasonable basis that my client hasn't consumed any alcohol, that can be addressed by her in the court. But again, I believe the directive from the court to my client would be more than sufficient to ensure the safety of this minor child. There has been some reports that from the respondent mother that there is very little past contact between my client and the child. I believe that was refuted very fully in his declaration, where he supplied. And I have always been told that pictures are worth 1,000 words. The pictures that we submitted to the court, though they are in black and white, it is very obvious that this child, during the period of time that my client was with the respondent mother, that there was a significant relationship. He indicated that he cared for the child. He cared for the child when the respondent mother went to work, and if the respondent mother was not available, he was in fact the primary caretaker for this child. All in all, Judge, I believe that it's appropriate today, after these many months. My client has been very patient. He's been a very calm individual, a very sensitive individual to the court's needs, to my needs, and more importantly, to the best interest of his child. I believe it's time at this point in time that we move forward, that we initially go with a day visitation for the first 4 weeks, that either on Saturday or Sunday, as the court designates, that he would have contact with that child from 9 o'clock in the morning until 5 o'clock at night. Upon the completion of that 4-week period of time, assuming that there are no concerns expressed, that we move then into a overnight mode for a weekend. We do that for 4 weeks, and then at the conclusion of the 8 weeks, we go back to what my client is seeking, and that is a 50-50 visitation schedule shared with the respondent mother, where my client would have an opportunity to be with this child 50% of the time. I believe that should satisfy some of the court's concerns, but if you have any questions, Judge Evans, I am here for any questions, any queries that you have. Thank you.
Thank you, Mr. Brungart. I don't have any questions for you at this point. I'll hear from, please, Ms. Nilsson.
The police reports that I did turn in, the guns he did have in the safe were taken into custody. The gun that he had used that night, we were not able to find, which turned his, I guess, police hearing custody thing into a misdemeanor because we could not find the gun. He did stash it somewhere. I have torn the house inside out, upside down to try and find that weapon that he used that night for the police. And because it was not found, that's why it turned into a misdemeanor. The baby gate was not thrown at my ankle. It was thrown at my shin. And there was a bruise there for about a week and a half. I was in counseling at that time and had been now out of it for quite some time due to being busy with my daughter and work. The only time Roy had seen Paisley was the time he got off of work, when I got home, and on weekends when I did have to work. And at that time, she would even cry for me not to leave because she did not want her father. On top of that, the incident before that, my daughter was in my arms and he had spat in my face. My parents lived with me at that time, and my mother was there. My family has seen the abuse and has been there for me since it all started. Of course, he's going to say that it did not happen, but I have pictures for proof of marks on my body that he has left. My daughter has trauma from it, and we both are now at this point having hard time sleeping throughout the night due to such trauma. My daughter is very important to me. She always comes first. Even if I was at work, I was always checking up on her, making sure everything was all right, and have told people who did watch her, if they need me, call me and I'll be there ASAP. A lot of the time that he would have her, he would often have his family watch her due to him wanting to go fishing and be with his buddies when it was his time to be with her. So at this point, I do want supervised visitation. And
can I ask you a question on that point?
Yeah.
Do you have a suggested supervisor?
I do. She used to be I believe a paralegal. So she has experience in being a supervisor for parents. Her name is Tara Hargrave.
And does she charge a fee?
No, she doesn't. She is willing and able to be there.
Okay. All right. Thanks. Go ahead, please.
I have always been in my daughter's life. He has told me that I baby her too much, and I'm around her too much, that I need to stop babying her, and such and foremost. Like I said before, my daughter is number one priority. So he has often not been around her throughout her life. Most of the time, he's not home until roughly 5-6 o'clock in the afternoon, unless it was a Friday. Then it was about 3 or 4 o'clock in the afternoon. Even when he was home, when we were together and living together, he'd instantly go for the fridge for a beer or sit down and play video games while I'm taking care of my daughter. I personally don't think that 50-50 custody is okay at this point in time until he can prove that he is fit and able to be a parent to her. And I do want the alcohol and drug evaluations done and would like the court to receive proof of the alcohol and evaluation, and they're not to have that around her when he is visiting her.
Okay, thank you. Mr. Brunkard?
Judge, we're ready to proceed.
Thank you. All right, my sense here is that what I'd like to see happen here is for there to have Mr. Daly get a substance use disorder evaluation and also obtain a domestic violence evaluation. And until those are completed and we see what the recommendations are, that I think there should be some supervised visitation for the father. It sounds like there hasn't been much, and I know that there's concerns on Ms. Nilsson's end, and yet it's important that contact continue. And I guess I wanted to ask Mr. Brungart, Tara Hargrave sounds like an interested third party that could serve as a supervisor at no cost. Do you or your client have any input on that person?
As long as she is a neutral third-party person who's willing to do this without a professional fee, we would adopt her, and I would just ask the court to inquire as to the proper spelling so I can include that in the order.
Thank you. So until those evaluations have been completed, I'm ordering that there be a midweek visit of 2 hours. That could be between 5 and 7 p.m. If the parties can't agree, if you want to do it earlier, that's fine. But if you can't agree, then it'll be Wednesday, 5 to 7. And I'm fine if you agree to change it to a different date if it works better for everybody's schedule. But if you can't agree, then it'll be Wednesday, 5 to 7, 2 hours every week. And then 4 hours on Saturday, noon to 4. Again, the parties can change that to a Sunday and the hours can be different. But if you can't agree, then it'll be Saturday at noon to 4. That'll continue until we have a hearing when the evaluations have been brought back and are before the court. And we'll see what the evaluations recommend. And then we'll take a look at what the next steps would be as far as parenting time for Mr. Daly and the child. So at this point, I'm not planning on setting a hearing date. There's a lot of time and effort to get those evaluations, and I don't know how long it's going to take. It's somewhat imprecise. Once those have been completed, I would anticipate they would be filed under seal and copies provided to all parties. And then we can then it could be noted up for a hearing and take a look at those. It should be noted also that for the domestic violence evaluation and the SUD evaluation, that collateral input will be given by Ms. Nilsson and others, but definitely Ms. Nilsson. And so that means Mr. Daly would need to sign a release of information allowing for Ms. Nilsson to receive provide that input to both evaluations. So that's where we are with today's decision. We could take a look at coming back next week as far as a presentation of that order, or we could take a look at 2 weeks. Any preference?
Judge, let's do 2 weeks, sir.
2 weeks?
The 14th.
Okay, November 14th works for me. So Ms. Nilsson, my proposal is to come back on November 14th. Mr. Brungart will draft up an order from today's hearing, which requires the domestic violence evaluation, the SUD evaluation with collateral input from yourself, and that the listing of the visitation times, Wednesdays and Saturdays, for the time specified. That's what the order will say. And then we would be here on the 14th to review it and sign off on it. And then a future hearing would be determined later once the evaluations are done. Any questions, Ms. Nilsson?
When would the visitations start? Like, how soon would they start?
Next Wednesday.
Next Wednesday?
Yep.
And within that time period, I would receive the paperwork from Mr. Brungart and Roy for the evaluation and visitation paperwork for us to sign off on.
Yeah, he'll provide you a copy of what his proposed order is, and then when we're here on the 14th, if you have any concerns, you can air them at that time.
Okay.
Okay. All right. Mr. Brungart, any final items?
The final item is, I don't believe that the respondent has an address at this time. Would Your Honor inquire so I can send by certified mail and or, regular mail a copy of the proposed order to what address?
Yeah, let me ask Ms. Nilsson, in your recent pleadings, you used an address in Longview address?
Can I have it sent to a different address?
You can, and would you prefer providing that over, because everything's being streamed live via YouTube. Some people have sensitivity to that. Or if that's something that you could provide an address to Mr. Brungart over this medium or through a phone call, or what's your preference?
What's his email, and I can email it to him.
Yes, ma'am.
Okay.
Great. So
I will get that address sent over to you as soon as I can.
Great. And then also
Thank you, Judge.
One item, be aware, Ms. Nilsson, that if you need to keep an address updated with the court so everybody knows where to send documents to you. So if the 8th Avenue address is not a good address anymore, you could be served papers at that location. And if you're not there, then you're not going to receive notice of a hearing. So it's important to keep your address updated, just to give you that little FYI.
Yes, Your Honor. I wasn't sure how to exactly go about getting address to the court.
You can check with the clerk's office and you can file basically an updated address. They'll give you a hand with that.
Okay.
Okay, great. All right, thank you all. Appreciate it. We'll see you in a couple of weeks. There we have
Thank
Ms.
you, Your
Bliss,
Honor.
representing, yep, there's just Ms. Bliss is present representing, pardon me, Taylor Flick. And is Isaac Bondurant on the line today? Isaac Bondurant?
Yes, sir, I'm here.
Okay, welcome to you, Mr. Bondurant. Give me just one moment as I pull up my notes, and I apologize. Okay. This comes before the court on Ms. Flick's motion for adequate cause to modify a parenting plan. We were here before, and Mr. Bondurant asked for some additional time, and I've read his pleadings. And so I think we're ready to go. I'll hear from Ms. Bliss and then from Mr. Bondurant, please.
Thank you, Your Honor. And for the record, Carly Bliss on behalf of Petitioner Taylor Flick, who is the moving party before Your Honor today. As Your Honor summarized, we are before the court on my client's request for a modification to the parenting plan. There is also a request for a restraining order. Both have been heard by the court or reviewed by the court, I imagine. One question preliminarily, did Your Honor have the opportunity to review my client's reply declaration that was sent over very late? It was yesterday. So there is that issue.
Yeah, let's see. I wasn't in the office at all yesterday. So I was handed some proposed orders. So I think the answer is no.
Okay, and that's fine. I have no issue proceeding regardless. There was some objection that I contained within that declaration. So I would just note those for the record as well, for Your Honor. Mr. Bondurant provided my summarization of nearly 100 pages of responsive declarations, pleadings, exhibits. I don't know the exact number off the top of my head, but there was significant statements provided. I would note that his responsive declaration was, I believe, 27 or 28 pages, single spaced. Obviously, that goes beyond Local Rule 88. Also contained within his pleadings were exhibits which appeared to have been declarations prepared by other folks, not sworn under penalty of perjury. Obviously, those are inappropriate as well, so I would ask the court to not consider any of those pleadings. Further, I did make a request that the court not consider any of the pleadings provided by Mr. Bondurant, given the fact that Your Honor did give him a firm due date of October 10th. Those were not provided to the court until October 17th, nor provided to my office until October 18th. So those are my preliminary requests today, obviously deferring to Your Honor. If I need to go into more argument, I'm more than happy to, if Your Honor is going to consider any of his pleadings.
No, that's fine. Thank you. So let me just touch base with Mr. Mr. Bondurant. Mr. Bondurant, there was your submission that was filed on October 17th. And it looks, I counted 26 handwritten pages of basically your statement. And then you had a declaration from another individual. And so there's page limits that are that, which kind of makes sense, because when I get a 149 page pleading just for one setting, for one case, that's a lot. And as you've seen today, there's about 20 cases on today. So there's necessarily some time constraints. And so those rules are in place to say, hey, look, we've got some page limits here. And so what I did, I kind of gave you the benefit of the doubt. You submitted 26 pages of your declaration. I stopped reading at 12. And then the other individual, they needed to make their declaration under penalty of perjury. And that gives the person, kind of puts them on notice, like, hey, what I'm saying here is really important. I have to be factually correct. And that was absent. Their reply didn't have that. Secondarily, their reply was too long, needs to be limited also. So I read a portion of that, and then I stopped because it was beyond length. But Ms. Bliss raises a good point as far as the under penalty of perjury language being absent. So I just want to give you a voice to that issue. So if you want to address that just briefly, Mr. Bondurant, you can.
Yes, Your Honor. What I can say is I'm not an attorney. I have no skill in that department. I do know it's very hard to summarize. I mean, to you guys, it seems 26 pages seems like a lot when it comes to your children, but that was the beginning. I mean, these kids are my whole world, so that was easy to sit down and write this about my kids. I mean, and if, Your Honor, if all you were able to get through was 12 pages of my declaration, but you were able to see all the pictures, it's clear to see who I am as a person, what's being pressed that is incorrect. It's stuff to just diminish my name. All this can be proven. I have proved all of it. She said I was pulled over for a DUI, probably on drugs.
So we won't go to the kind of the specifics. I just wanted to just give you a voice on the issue of kind of the overlength. So I've kind of told you where I'm at, and so that's great. I appreciate that. You'll have opportunity to discuss in detail your concerns. So I'll turn the time to Ms. Bliss.
Thank you, Your Honor. And before the court, obviously, it's my client's petition to modify the parenting plan, given the significant concerns my client raises in her declarations. I note at least 6 different major issues that she reports in her declaration to give rise to this motion and this petition. Looking first to the DUI, my client provides in her declaration and within her exhibits. At that point, all she had available to her was a screenshot of the booking information, and that is contained in my client's, I believe, Exhibit 1 of her initial declaration, indicating Mr. Bondurant was arrested in Springfield, Oregon, or thereabouts, under the suspicion of driving while intoxicated. My client raised significant concerns regarding this, as Mr. Bondurant had also had a DUI back in 2016, to which he was on diversion for. I understand that his diversion has since been revoked and his license has been suspended. On that same vein, my client provides significant concerns. There are video and photographic evidence of Mr. Bondurant continuing to drive with the children, continuing to drive while smoking marijuana, continuing to drive with the children not in proper safety restraints, not in booster seats, in the front seat, on his lap, and the like. The fact that Mr. Bondurant fails to protect these children, these very tender age children, ages 5 and 4, to that extent, is just the tip of the iceberg. Very concerning. It's my understanding that his license has since been suspended. My client is requesting specific language that prevents Mr. Bondurant from driving these children at all, at least for the foreseeable future, especially given the suspension, especially given his attitudes towards the suspension. My client provides that he is very active on social media. I think even his responsive pleadings indicate this. If Your Honor were to review any of the videos provided regarding this issue, it's very telling that Mr. Bondurant is defiant towards authorities, is defiant towards court orders. Obviously, driving while intoxicated speaks volumes for itself. Looking next to the verbal aggression, derogatory statements, and the like made towards my client, not only in front of the children, which is disturbing enough, but also, again, on social media, referring to my client in very derogatory names. My client provides there's one specific incident back in July when Mr. Bondurant and his wife came into her home to retrieve the children, started screaming profanities at her, calling her a effing B in front of the children. Again, these are very tender age children. This behavior is completely completely inappropriate. And there does need to be some limitations contained in the parenting plan that prevents this from continuing. Another issue brought forth in my client's declaration and is very concerning is the overly sexualized behavior that is being exposed to the 5-year-old child in this matter. There's discussion in there regarding the 8-year-old stepchild of Mr. Bondurant French kissing the 5-year-old in this matter, grabbing her face, not letting it go. My client indicates she's questioned by their 5-year-old what French kissing is, why her sister had done that. And Mr. Bondurant's statements are essentially dismissive, that never happened. Why weren't the police called? My client provides in her responsive pleadings filed yesterday that the police were called, CPS were notified. It's her understanding there are active investigations regarding that issue. But the fact that it is so dismissive leads my client to believe either Mr. Bondurant's household is condoning that behavior or they're simply just not supervising these young children, both of which are equally as concerning. Obviously, there was a contempt brought forth before the court to have my client retrieve the child. Mr. Bondurant kept one of the oldest child, for upwards of a month and refused to return her, but for that contempt motion being filed. Obviously, that is deeply concerning. My client also provides for the court the continued detrimental statements being said to the child. Upon receiving the child from Mr. Bondurant, the child expressed fears, nightmares, saying that Daddy and Mommy Courtney were going to kill my client, drown her in the river. These are very concerning statements, again, for any child, especially a 5-year-old child. A child that is now expressing fear having to go back to her parents' household, given those significantly concerning statements. And lastly, but most concerning, was the overdose in August. My client provides for the court that she was notified, did independent research to learn that Mr. Bondurant and his wife consumed fentanyl-laced cocaine. I see in Mr. Bondurant's responsive pleadings, he indicates it was a fentanyl-laced joint, marijuana. However, also contained in my client's reply declaration is there's ring cam footage from the date that Mr. Bondurant was released from the hospital, came to my client's home, indicated he came to quote unquote show the children that I'm not dead, and he went over to a home and did a little bit of cocaine that, unbeknownst to him, was laced with fentanyl. Again, the minimization of drug use, whether it's legal substances as marijuana or illegal substances as cocaine and fentanyl, both are equally concerning. My client provides significant documentation regarding the marijuana usage. Mr. Bondurant holding up bags, gallon bags full of marijuana. Again, whether it's a legal substance or not, the children should not be exposed to that. My client has concerns that there is some illegal activity within the home, selling of drugs. Obviously, the usage of cocaine and fentanyl, either at Mr. Bondurant's home or his neighbor's home. The circumstances surrounding the overdose are equally as concerning. Obviously, if he was allegedly at his neighbor's home, started to feel unwell, as he put it, was leaving said home and essentially collapsed outside of his home. Narcan needed to be administered to save him. He was rushed to the hospital, was in the hospital for a period of time. All of this is deeply concerning, and the fact that Mr. Bondurant is minimizing the effects of not only this on his life, but on his children's life, who could have been exposed to this. There were children, my client's understanding, within the home when this incident occurred. Again, having this type of drug use with these tender-age children and not having any sort of safeguards in place are very concerning. So the request before the court today, from my client's perspective, is to either suspend visitation, which is currently the status quo with the restraining order, or require professionally supervised visitation pending a substance abuse evaluation. I note in Mr. Bondurant's responsive documents, he indicated, he's in some sort of treatment or is undergoing some sort of UAs, hair follicles. None of that has been provided. So there's no way to determine if there is any sort of sobriety. He claims, they only tested positive for marijuana. Again, my client would argue that's also inappropriate, especially given the tender age nature of these children. But frankly, there's nothing to substantiate any of his allegations or any of his claims to prove otherwise. So what there is before the court is substantial documentation, substantial photographic video evidence that there are some significant issues here. So we are asking the court to find adequate cause to modify the parenting plan, given the various concerns I've just provided and recapped. I think a guardian ad litem is probably appropriate in this matter, especially given, again, the tender age nature of the children, the severity of the concerns provided. And that is, we're asking the court to order professionally supervised visitation pending that substance abuse evaluation, pending proof of sobriety, and pending a further word from the guardian ad litem.
Thank you, Ms. West. Mr. Bondurant, I'll hear from you, please.
Yes, so I guess I'll start with the overdose. That is still active, an active investigation. The story behind that, our kids were not at the house. My wife's mother was here. We had gone over to my friend's house, and yes, we smoked a legal joint, which is we are allowed to do. We had it gotten passed to us, and it happens all the time. Talked to him at the hospital. Somehow it was laced with fentanyl. The guy's vehicle was impounded. He had belongings taken from him that day. I did not. They were allowed into my house and they found nothing. This is an investigation into a poisoning. Okay, that is all that is. And that is public information if the lawyer would do her research. On top of the fact that, excuse me, this is being taken. She's trying to paint a picture like I'm just this terrible human individual. That is not the case. She references me being a drug dealer, me holding up gallon-sized bags of drugs. My friend, he grows for a dispensary, and it was 2 Ziploc baggies, approximately about a pound of marijuana. And I took a picture of it. I also have a TikTok where I goof off. I portray myself to be one way. It's social media. You could be anyone you want to be, okay? And they're just trying to spin any video they can, anything they can against me to paint this picture. Oh, also, my arrest, she's referring to the DUI. I was arrested for a warrant for an old DUI when I was still actually married to Taylor Flick. I just hadn't taken care of it. So when my wife got pulled over, they ran my name because she has a protection order against her ex, and they had to make sure I wasn't him. And it came up that I had a warrant out for my arrest. So I was arrested, taken to Lane County Jail, and extradited back to Oregon. I have since taken care of all that. I'm not on probation. I'm not wanted in Oregon. And as it pertains to video evidence of me driving around with my kids and not in car seats and not safetied up, that is also not the case. These are pictures of just sitting in a car, a stationary car, and I'm doing TikToks and I'm taking pictures with my kids. I do not smoke marijuana in the car with my kids. My wife drives 99% of the time. I haven't gotten behind the wheel in 4 months, especially after my arrest. I definitely don't play around with it because yes, Your Honor, I am revoked. There's so much that is being portrayed in these by Mrs. Flick. The day that she says that names were called, we actively called the police on her. Her mother assaulted my wife. And because it was 3 against 2, the charges went nowhere. I don't even know, again, I'm not an attorney. I probably sound all over the place. I don't get paid to be an attorney. I'm just a dad that's trying to make sure he doesn't get railroaded by the courts on something that a picture is being painted that any amount of looking into, you could see the truth. In my exhibit, it might have had a lot of documents, but if you read the whole thing, which I'm sorry you didn't, it states everywhere. She's making claims against me. I'm proving myself. That's what it says in there. That's what these pictures are. The CPS when CPS was here, the CPS case has already been closed. It's been closed for about a month and a half. We're just waiting for the paperwork, and we'll be able to show the courts that I am in treatment, and it's not for cocaine use because I've never had a cocaine issue. I had my appendix removed. I had surgery, and I was on pills, and then I did for a while there. I did get out of hand with pills, so I made sure on my own I went into Ideal Options and sought treatment. And I've peed clean because I don't do drugs. I will submit to a hair follicle. That's fine. And a guardian litem. That's fine. I'm not a super good talker, Your Honor, but with people actually coming here, seeing CPS knows who I am as a father. Taylor knows who I am as a father. This is purely out of spite. And unfortunately, we're in Washington State and I'm a father here, so we know how that goes.
How does that go? I don't know how that goes. How does that go?
I won 50-50 custody of my children. She didn't show up to court. Okay. I was awarded 50-50 custody for a reason, because I am a stand-up dad. because I provide for my kids, because I protect my kids. That's who I am as a father. Taylor knows that. And at the end of the day, the courts are going to make whatever ruling they want to make. I haven't seen my girls in almost 4 months. And you guys are expecting me, the courts, Taylor, anybody expecting me to live any kind of a normal life when the only piece of normalcy I have, she's been able to take from me on a whim. This is not the first time she's done this to me. Anytime I have anything to say or I stand up to myself, this is the situation I get put in. Okay. We don't get to talk about when she was cheating on me when she was pregnant and I had to get a paternity test to find out if Kinley was mine. We're not talking about any of that stuff, though. She just wants to slander my name. The problem is I could slander her name with facts and she can slander my name with lies. That's what this boils down to.
Okay. Thank you, Mr. Bondurant. Ms. Bliss, any reply?
There we go. Again, Your Honor, nothing has been provided to substantiate Mr. Bondurant's statements of sobriety, statements that CPS is closed and unfounded. Nothing even, frankly, from the police indicating that it is an active investigation to substantiate his series of events, which are unfortunately for him, contrary to the evidence that's been provided to the court. This isn't an issue of slandering one another, but I do believe that that's a big underlying issue between these parties' co-parenting relationships. And I think that that is borne out by the evidence that's been provided. It's an issue of safety and protecting these two young children, something that I don't believe Mr. Bondurant is currently capable of doing at this time. So we do believe that our requests are appropriate. We do believe that they are necessary in order to continue protecting these kids.
Thanks. Okay, I just wanted to circle back to that. The
And if
page
I can add,
limitation.
Your Honor, if I could just add one more thing.
Sure.
CPS came to this house and they were advocates for us keeping our children. Okay. I've asked for these records. Okay. I cannot make them work any faster. But what a lawyer can do that has no problem spouting off a bunch of wild, obscene comments that she doesn't know actually what she's talking about. She's literally just taking what Taylor Flick is saying, not even looking into it, not looking out for her client, because what's going to happen is I will be able to afford an attorney here soon down the road that will properly represent me. Okay. And this will be something that this is not going to be over with. I can guarantee you that when I have proper representation, okay, and I have someone speaking for me on truths, okay, Taylor's lies are going to come out and I will have full custody of my kids.
All right. Thank you, Mr. Bondurant. I just wanted to circle back to the page limitation and just let Mr. Bondurant know where to find that. If you go to the Cowlitz County Superior Court webpage, which is cowlitzsuperiorcourt.us, and you look under rules, there's on the top left, one of the main headers, it says rules. And if you click on that, if you look at Rule 88, it'll give you the rule related to page links, so for future reference. So here there's a motion for adequate cause. Basically, has there been a substantial change for the court to look at making a change to the parenting provisions in the parenting plan that's been previously put in place? So here there's, obviously there's dispute between the parties as to what things mean or what's going on. As far as the DUI, we know that there was a prior DUI conviction in 2016. Apparently, it was diverted. And so this current one, there's some ambiguity whether it was a DUI arrest or if it was some type of citation or what have you, and simply an arrest on a warrant. One thing I think is that rings loudly when you take into account the prior DUI in 2016, and then what Mr. Bondurant represented, that he said that, I believe, related to the overdose, that when I look at that overdose issue, even if I take Mr. Bondurant's statements at face value, which I do, he said that there was an individual that they didn't know, they gave them a joint, and then they smoked it. And
Your Honor, it was one of my good friends' buddies. He knew him. I did not. So it was like we were in a circle and a joint gets passed around.
Right.
And
so with the joint being passed around, it's fairly common knowledge in drug using circles that fentanyl gets laced with a bunch of stuff, including marijuana. So while the person there may be a friend of a friend, it's still placing confidence in that friend to vouch for this other friend that they got it from a clean source and there's no lacing is, at least in my opinion, reckless, because it's very common knowledge that that happens with some regularity. So unfortunately, that occurred. Fortunately, the Narcan was administered, and thank goodness. Both parents, Mr. Bondurant and his spouse, are still here. That's a beautiful, great, good thing. But I take that overdose issue and the consumption of marijuana of an unknown source with the prevalence of fentanyl. I take that into consideration with what I call kind of this glorification of drug culture or drug consumption. I recognize that marijuana is legal. It is legal. Alcohol is legal. Food is legal. We abuse a lot of those things. Many of us abuse alcohol. Many of us abuse marijuana. Many of us overeat. Many of us do a lot of things. We don't get enough sleep. And some of those things that we do impact parenting. So I say that because those things raise a level of concern that there is this maybe an over focus, or maybe that there's been a lack of volitional control when it comes to certain substances, pardon me, and it may have an impact on parenting.
Your Honor,
Issue of sexualized, this isn't an opportunity for back and forth discussion. I've heard from both parties and I'm giving you my ruling at this point. So there's concern for sexualized behavior related to the French kissing incident. I read both parties, what you had to say about that. There's also issues related to, I'll leave it at that. So, there's also the issue of the driving license being revoked. And I recognize a lot of people that are revoked drive. In our size of our community, the size and distance between things, it almost becomes a necessity to drive. So I'm very aware that people who are suspended drive with regularity, if not infrequently. And Mr. Bondurant's own statement indicated 99% of the time I don't drive. There you go. So there's indications that if Mr. Bondurant were to drive and not be licensed and there were to be an accident, there could be some liability and concerns where the children may not be fully taken care of or provided for. That's a concern. That all leads me to believe that there is adequate cause. So I'll grant the motion for adequate cause to modify, pardon me, the parenting plan. There's also issues related to, one thing I forgot to mention was related to, I'm happy to hear that Mr. Bondurant is currently in treatment for past abuse of prescription pills. That's great. That's important and noble and good. I'm glad he's doing that. When combined with the other concerns, I think that a new SUD evaluation with collateralized input from Ms. Flick would be appropriate. So I'm going to require that. Pending the outcome of that SUD evaluation, the supervision with the girls and visits of dad will be professionally supervised. Once we get those results back, we can certainly or quickly look at that and change that if needs be. I will appoint a guardian ad litem to investigate the case. It'll be a county pay case. And they are to look into all issues related to parental, pardon me, the well-being of the children, including SUD issues, driving status, any of the number of concerns that have been raised here today. So that's the court's order at this point. Does any party have any questions?
Yeah, my only question would be, so from here going forward, am I just not allowed to contact my children at all? Because that's fine
No,
if you
may.
hang on, Your Honor. Your Honor,
You may.
can I
Your
say
question, I'm entertaining questions at this point. Do you have a question?
Yeah, that's a question. I want to know how long you're going to keep it from my
yes,
kids.
you can have contact with your children. It'll be supervised visitation.
No, like over the phone. I can't call my kids. I can't call my kids. I haven't talked to my kids in 4 months. That's not a problem. That's going to help with people's sobriety, Your Honor.
So no need to be confrontational with me, Mr. Bondurant.
I'm not being confrontational.
You are, and if you would like to have telephone contact with your children, you could say, Your Honor, what about telephone contact with my children? I'd be more than happy to entertain that question.
Your Honor, what about telephone contact with my children?
Ms. Bliss?
I don't necessarily think my client would have any issue with that so long as it's supervised.
I'm fine with telephone conversation between the father and his children. Pardon me, 3 times a week for up to 30 minutes. Do you have any other questions, Mr. Bondurant?
Sounds like you have more rights to my kids than I do. Nope.
Is that a question, sir?
No, I don't have a damn question for you.
Please refrain from swearing in my courtroom. The record will reflect that Mr. Bondurant exited the courtroom when I told him to abide by my rule. Ms. Bliss, if you'll provide a proposed order, and we will come back in 2 weeks.
Your Honor, I don't know, given his removal of himself, if you're willing to entertain this request, but with regard to those phone contacts, to limit the derogatory statements and conversations with the children, to obviously not include any litigation.
Given his inability to keep it together during today's hearing and his confrontational attitude and is quick to lose his composure, I'm revoking that permission. So there will be no phone contact until we come back again and we can have a discussion about his ability to moderate himself.
Very good. Do we want to set presentation for 2 weeks?
Yeah, let's set it for the 14th of November.
Very good. Thank you, Judge.
Mine's gonna be quick, I promise, Judge.
Yeah. I believe that Ms. Bliss and I can keep our argument relatively tight as well.
I would agree.
Okay, let me okay. It looks like Mr. Bondurant's coming back on.
Okay.
Just 1 moment, please. Mr. Bondurant, we lost you there. Oops. All right, Mr. Bondurant, we lost you there. It looks like you're back on the line. Can you hear me?
Yes.
Okay. So as indicated at the time that you disconnected, I'd asked you please to refrain from swearing in the courtroom, and then you immediately dropped off at that point.
Is that a question?
Nope, just a statement.
Okay. I dropped my phone. I called back.
And then after you had left the call, Ms. Bliss, help me remind me. I think you had made a request for something.
Some limiting language regarding the telephone contact with the children, just the standard refraining from discussing legal matters with them, speaking derogatorily of the other parent.
Okay, so I wanted to make sure, Mr. Bondurant, you heard that. And then do you have any comments related to if there were to be a restriction on the phone calls related to not allowing you to make any derogatory comments towards the mother?
No, I have no questions in regards to that. I have two questions though. So would that mean that the restraining orders are still in place on my children? Because I don't mind if there's one, like I said, if Taylor wants one. But how am I to contact my kids if I'm restrained from them? And then what would be the schedule that I'm allowed to call my kids so it doesn't get confused?
So as far as a restraining order, Ms. Bliss, do you have any information about that?
And Your Honor, at this point, given Your Honor's ruling, I think so long as we have some very clear language in there as to types of behavior, that at this time, restraining order is no longer necessary.
Go, dude.
Okay, so the restraining order is hereby rescinded. It's no more. And then there was also in your absence, Mr. Bondurant, there was a discussion related to your lack of moderation in the hearing. And I made a decision without you being present that the phone calls were not going to continue that I had just granted earlier. My basis for doing that was that I found your behavior toward the court to be somewhat presumptuous, aggressive, and kind of defiant in a way. Certainly people disagree with my rulings, but they do so in a moderated way. And I was concerned by what I deemed to be the dropping of the call. I didn't think it was a drop of the call. I thought it was a termination of the call by you just being frustrated.
Why would I call back
then? Let's go ahead and talk about that. Let's talk about the phone calls. You indicated that you're still interested in having those phone calls, correct?
Didn't you say you were just rescinding the offer?
I indicated in your absence that's what I did. And so now you had indicated you wanted to talk about the days and times of the phone call, so there wasn't any question. So I'm inclined to reinstate those.
It seems he may have dropped off again.
Mr. Bondurant apparently dropped his phone again. Looks like you're back, Mr. Bondurant.
Yes, I'm not hanging up intentionally. No, I'm in a car and it keeps dropping the calls. I didn't hang up the first time. I lost my cool, absolutely. But no, I'm not hanging up, but that's fine. Yeah, I'm asking about a schedule, Your Honor. What
Yes, we're
days I can
talking
call my
about
kids.
phone call schedules. Do you have a proposed schedule that you would prefer?
Nope, whatever suits best for Taylor's needs.
Could we look at maybe, I'm not sure, maybe sometime just right after dinner, Monday, Wednesday, Friday?
Whatever you want, Your Honor. Whatever sounds good to you guys.
Ms. Bliss?
I'll confirm with my client. I don't imagine that would be an issue. If it is, I'll make contact with Mr. Bondurant. If he chooses to reply, that's on him.
Okay, so let's do this. Monday, Wednesday, Friday, 7 p.m. up to 30 minutes. And if the parties agree to something different, great, they can do it different. But if they can't agree, then it'll be Monday, Wednesday, Friday, 7 p.m. Okay, so I think those are the issues that we had discussed in Mr. Bondurant's absence when he dropped off the first time. Oh, and then also we set what's called a presentation date, November 14th, Tuesday at 9 o'clock will be the presentation date. That's where Ms. Bliss will summarize the court's rulings, oral rulings today, and put them in paper. She'll send a copy to Mr. Bondurant, and Mr. Bondurant has any objections to that, or he feels that the court didn't get it right, then we'll be here on the 14th to discuss that and work it out. So any questions?
The only remaining issue, Your Honor, is to getting the next 3 names for the guardian ad litem.
Repeat that again, please.
Sorry, the next 3 names for the guardian ad litem. I don't think we did that.
Yeah, thank you. So in choosing the guardian ad litem, I appreciate that. The clerk keeps a list of the next 3 individuals who come up on the guardian ad litem list. So I'll ask the court clerk to read the next 3 names, please.
The next 3 names are Heather Kell, Amy Turnbull, and Ann Height.
Okay, and with that, so with those 3 names, each party has the right to strike 1 name. So Ms. Bliss, do you have any strikes?
I do not, Your Honor. I'm fine with Ms. Kill.
Okay, and Mr. Bondurant, you have the right to strike 1 of those individuals. Would you like to strike any one of them?
Nope.
All right, Heather Kell is appointed, and she will reach out to the parties, and then please make sure that you respond quickly to her. And the sooner you respond, the sooner she can get going on the work and get information to the court. All right, so we'll be back on November 14th. Is Jason Bain here?
He is and present via Zoom, as is Ms. Bliss's client. And then just for the record, this is Ms. Bliss's motion, but I do object to the declarations that were filed in reply contain new information that was never pled previously. I'll let Your Honor sort of take it from there.
Okay, and then Ms. Bliss, does your client prefer Betty. Angel Leon? Is it
Betty Lyon is the name that she it goes by now, and I believe it was legally changed after the divorce was finalized.
And it's Lyon.
Correct.
Okay, great. Thanks. I appreciate that. Okay, let me just get my notes here. Okay, thanks. I'll hear from Ms. Bliss.
Thank you, Your Honor, and I will keep my arguments brief. As Your Honor was looking through the file, you likely saw quite a large period of time lapsed between the time the petition was filed and obviously we're before the court today. The parties tried diligently to reach a resolution. Unfortunately, we fell short. My client indicates in her reply declaration that her requests for the court have changed and have been reduced to the sole issue of revising transportation and child support. Looking to transportation, my client provides, she lives in Raymond, Mr. lives here in Longview. To date, she's provided 100% of all transportation. At the time, prior to this motion being filed, visits were happening outside of my client's home. Now they're happening inside my client's home, and that was by agreement of the parties. So I do applaud them from reaching that resolution. Now comes the issue of my client coming to Longview, returning the children to Raymond late in the evenings on both Fridays and Sundays. My client provides in her declaration that her eyesight is substantially affected at this point, causing issues with night driving. My client's request for the court is simple. The parties meet both ways in Boysport in a mini mart. It's 45-minute drive for both parties. To slightly shift the timing of when pickups and drop-offs happen to 6:15 on Friday and 4 p.m. on Sundays. My client provides for the court that this will assist with having daylight out in the world as she's driving for that. Looking to getting assistance for driving. Obviously, Ms. Baldwin lodged an objection. I don't know what Your Honor's ruling was on that, but she did provide some declarations from folks that have assisted her with driving. I trust that Your Honor has read those, whether you consider those or not. The facts before the court is there have been a substantial change of circumstances. My client cannot continue to provide 100% of the transportation. She's simply asking for the parties to meet in the middle, and that's reasonable. My client is providing currently 100% of the transportation, not getting any sort of deduction to child support due to that. So she is asking the court to also address child support. If the court maintains the provision of her providing 100% of the transportation, she's asking that you take that into consideration when determining child support. Child support hasn't been addressed in the last 2 years, and my client provides for you that at the time of entry of final orders, her income was imputed by Ms. Baldwin and Mr. Vane. Now she provides for the court a clearer picture of what her actual income is, and it's different. It's not the same as what everybody suspected that she would be making at this time. So she's simply asking the court to use her actual income for purposes of child support, and that we modify it accordingly. Mr. did not provide any sort of financials for us to run any sort of child support worksheets. We're simply asking that he provide that so we can run new worksheets, and those are our requests for the court today.
Thank you, Ms. Bliss. Ms. Baldwin.
Thank you. So in this case, I did object to the pleadings on reply, and it's important that we think about all of the new allegations that are only raised on reply. And that's why in this case, it's more critical than it would be sort of in your average case, because essentially in this case, the petitioner tries to completely change the petition on reply, which is not appropriate. It's important to remember this is an agreed final parenting plan entered in 2021, just 2 years ago, after 5 years of litigation. That is not a small amount of time that this case was litigated. In that final parenting plan, there are critical findings noting the instability of the petitioner, her mental health problems that interfere with her ability to parent, and the risks of her choices and how those choices impact the children. The reality is that there is no change in circumstances in this case. They're limited to what they pled in the petition, not sort of the grab bag that's thrown in on the reply, but what they pled in the petition. So in this case, let's look at that. So the first complaint is essentially, I need to move the visit location from my grandparents' house to my aunt's house, essentially down the street. So it's not a different city. It's the same city. It's two homes that are very close. Number one, this was never asked for prior to them pleading for the modification. Number two, it's contemplated in the parenting plan itself. So this is not a change in circumstances. This is a change or an issue that's fully contemplated and thought about and planned for in the parenting plan that exists. It's expected. And we have an agreement. Once this was raised, my client said, of course, that's not a big deal. You can move the visit location from the grandparents' home to your aunt's home down the street. It's the same city. Again, so that doesn't create a change of circumstances to make that small change. So no change of circumstances regarding the change in the visit location, which is one of the two things that she pled. The second thing that she pled was a request to remove the restriction against her then husband. So there's a restriction in the parenting plan that children are not to have contact with this person because there was concerns about domestic violence, and the parties acknowledged that and entered a parenting plan reflecting that. After she filed the petition, and concerningly, days within essentially almost simultaneously filing this petition, she divorced her then husband, who the restriction applies to. So that's moved. We don't have an issue. She's saying remove this restriction, but that person's not part of her life anymore. So it doesn't create a change of circumstances because she's not going to have the children around that person who she's divorced now. So that issue's gone. Those are the two issues that she raises in the petition. You have to, this is a notice pleading state. It's not a free-for-all. You have to plead what the issues are. So the transportation, there isn't a change. There isn't a change in circumstances that warrants a change there either. Even though that wasn't really pled as part of the petition that there was any issues, there really isn't a change there either. This was an agreed parenting plan. Nothing's changed there. She sort of raises some issues that I would, again, only on reply, that I would argue are really just fiction, easily provable. She didn't prove them, easy to provide information on, and she's not providing that critical information that would actually substantiate those claims. But again, those are only raised in reply, which isn't reasonable to my client, and isn't how this process is designed to work. Child support is not an adequate cause issue. So her next complaint is sort of like, well, child support, she can file a child support modification easily. It's been, again, only 2 years. So child support hasn't been modified because it's only been 2 years. So we're just on the cusp of that being appropriate for a modification. But if child support's the issue, then that should be addressed through the proper process, not through modifying a parenting plan. Again, this is 5 years of litigation to get to an agreed parenting plan that's only been in place for 2 years. The whole point of having adequate cause hearings is to provide peace, peace for the parties, because peace for the parties we know is good for the children. The children having litigation, being upended, having constant litigation, it's not good for children. That's why we have the laws that we do. So in this case, there isn't adequate cause. There isn't a good reason to dive back into litigation after just a 2-year pause. We're barely at the point where you can modify child support, let alone open up a parenting plan for really no good reason. So in this case, the reasons presented just don't hold any water, or they aren't, or they frankly, she's admitted don't apply anymore based on what she's pled in the petition. The court must deny the adequate cause.
Thanks. Ms. Bliss?
Just for a point of clarification to Ms. Baldwin's statement that this is a notice date, I do take account of that. I would just note in my client's proposed parenting plan filed at the time of this petition, there were requested changes in the transportation language that are consistent with my client's request on reply. So I would just note that for the record.
And then Ms. Bliss, as far as the eyesight, tell me what supporting documentation supports the eyesight issue.
Aside from, I believe I filed some, let me look here. I know I filed some sealed healthcare records. I thought it was my understanding it would be in there,
September.
or maybe those were the.
Those are the mental health.
There we go. So no, my clients, aside from declarations from her and supplemental declarations filed on her behalf on reply, that's the information.
Okay, and then just the concern is just night driving is harder because her vision's not as good as it used to be.
Correct. She did indicate in her reply declaration that she did have cataract surgery in 2020, and since then it's gotten significantly worse.
Okay. All right. Thank you. Okay. So the initial motion, and I took notes back on this back in August, was for a motion to modify the parenting plan to allow the visitation at a particular home, and also to allow for the then spouse of the party to be present. So that's changed, and that there was the parenting plan that was proposed related to the transportation issue, the halfway issue. So, and that was raised more fully in the reply, as far as spelled out, this is what I want, as opposed to earlier on. Raising that on the reply is obviously somewhat difficult, because then another party is forced to either gain permission to file a surreply or what have you. So that, and also the child support request, there's a way that I think that's a more proper way of doing that is just simply filing a motion to modify any child support. So as far as the child support, I'll reserve any ruling on that, not make any ruling on that. If the parties want that to be raised, then they can certainly file that motion, so that the incomes can be looked at more carefully and precisely, if you will. As far as the adequate cause, I'm going to deny the motion for adequate cause. I recognize that the night driving can be hazardous and difficult for some, but I think that the nature in which it was raised, as far as on the reply, it's inadequate. So I'll deny that. Any questions or clarifications?
No. I believe I submitted an order, but it's also gotten sent over several times. So I think Ms. Bliss and I can work out the order. So even if you have one, I'm fine if the court just lets it go, and Ms. Bliss and I will work together to get that signed and submitted ex parte.
I would agree.
Okay, that sounds great. We'll plan on that. Thank you, Barbara Myers, and I see Mr. Brewer is present, assumedly representing Christopher Myers. Okay.
And thank you, Your Honor. That is correct.
Just a preliminary motion or issue with Mr. Brewer. Notice of appearance, has it been filed yet?
Well, Judge, what's interesting is we have two petitions. I put that in our materials. We actually filed petition first, they filed second. And so one of the issues was consolidating this. I'm happy to make an appearance in Mr. Sandy's case, but in Clark County, if we file first, usually we're the case number. So I'll leave that with the court.
And is there a case number?
Yes, Your Honor. That was in our response to materials.
So the issue with that, Judge, is my client was served. She was served a copy of a petition that didn't have a cause number. My assumption is she got served prior to that being filed. This case has been needing some temporary orders. We reached out to Mr. Brewer, we discussed, but we had already submitted our material. So I think both of them got served or filed on the same day. I think that's when they gave Mr. Brewer his cause number. Then a few minutes later, probably gave us ours. I think that's probably the timing of that.
Okay, so all right. So,
regardless, we do need to consolidate.
All right, so Mr. Brewer has his notice of appearance and his cause number, and Mr. Sandy's got his and this cause number. Is there
and here we are.
Any concern for consolidation under one particular cause number over another? Any numerologists out there?
I don't really think there is. I think practically speaking, we just under my cause number have the motion for temporary orders and the proposed order and such. I think it's I really don't think it matters tremendously.
Okay.
But given that we are here on my client's motion under that cause number, I think it probably makes more practical sense just to keep ours.
Mr. Brewer?
I don't have an objection to that, Your Honor.
Okay. And then just so the record's clear, we'll consolidate both cause numbers under this cause number. Great, thank you. So the 394 will be consolidated into the 396.
Very good.
Thank you. Mr. Sandy, this is, I believe, your client's motion.
It is, Judge. I'm going to be brief, I promise. I think this is a situation in which my client is before the court asking for primarily two forms of relief. Number one, I think, is already resolved itself. That's the temporary use and possession of the family home, which is located at 121 Swiftwater Place in Kelso. We are asking that that just be reduced to the order. It appears that Mr. Myers has already vacated that home. My client continues to reside in it. You see my client's position related to that home that was purchased prior to the marriage from what we believe were separate sources of funds. That home is in my client's name. Mr. Myers was sometime later added to that deed or financing purposes again for what we believe, and my client details for you, was added for to obtain a lower rate. So clearly financial purpose and financially driven, which I think the law is pretty clear under the Borgi case that remains separate in character. So we are asking that my client remain in that home. Also asking under that same vein for a prohibition against Mr. Myers from accessing the home. You saw some of the concerns detailed by my client. There are some mental health issues. How those are being addressed currently, we don't have a lot of information on that. I do not want to go into specifics. I trust Your Honor read the details of that, but nonetheless, that continues to be a concern of my client. To the best of our understanding, Mr. Myers has largely taken what he wanted out of the garage or the shop structure at the home. And my client details for you as well that there has been significant amounts of cash that he has kind of buried throughout the home. He's taken that too, to the best of our knowledge. So we're simply asking for the order to reflect that my client resides in the home on a temporary basis, and Mr. Myers is prohibited from accessing that home unless expressly authorized or agreed upon between, I would suggest, me and Mr. Brewer. Offices usually communicate fairly well. I think we could probably accommodate any information or any articles of personal property that need to be exchanged. But to the best of our knowledge, that's already been done. Mortgage on that home is a little over $1,000 per month, $1,021 to be specific. That's the big debt. My client also has some credit cards that she details for you. We are asking for the second form of relief in the motion, some kind of spousal support to get us through this transition time. My client quite literally is in financial straits right now. She needs to be able to pay her bills, buy groceries, buy gas and the like, the items that are referenced in her financial declaration that she provided for you. And I would say that budget is extremely modest, to the point of her claiming only about $150 for groceries a month, which given the prices at the local grocery stores is exceptionally low. Those prices continue to go up, but everything she has done, again, she is living exceptionally frugally, and we would like a little bit of support on a temporary basis to offset some of those costs. This is a 17-year marriage. Parties were married back in 2006. My client, certainly given the length of that marriage and the disparity of incomes, which I'll speak to in a moment, again, believes that the request for some support to give her some much needed financial relief is appropriate. As it pertains to the current incomes, Mr. Myers is a retired electrician. He has access to funds through Social Security, which is $2,135 per month. He also collects on a pension, which again is approximately $1,500 a month, and this Empower IRA. During the course of the marriage, there's some back and forth between the parties as to what was being taken and withdrawn from that. My client states at one time that was upwards of $1,500 to $2,000 per month. They reduced that once my client qualified and received her Social Security disability payment, which is $1,425, and Mr. Myers began taking $1,000 per month. He can take more. There's nearly $500,000 in that account. It's north of $400,000. Given his age and given his stage of retirement, he could basically reasonably take anywhere from $1,500 to $2,000 per month. And so again, that's an untapped resource that he's been modestly drawing off of, but that can fluctuate. What we're asking for is some support in the amount of $2,000 per month. Now, that would roughly equalize the incomes. After 17 years of marriage, we believe that's reasonable and appropriate, and we're asking you to adopt that form of relief. And my client just quite simply can't work. That's been determined by the administration. Now, she does have PTSD and a nerve impingement in her neck and back, which again goes to her extremities. It's very painful. It's an issue that she's dealt with for some time, and it's an issue that was acknowledged by both parties throughout the pendency of their marriage. There is some red herrings in this case. Mr. Myers states that my client is making money from as a musician, very part-time, as well as some pottery and artwork type of things. We've given you information on our reply that shows that just simply isn't accurate. My client details for you that she did sing at a function in which she was reimbursed for gas and basically her dinner that night. We've also given you information related to this artwork, which shows that it can only be described as a hobby, not a part-time job. And again, the musical stuff, my client can't play the guitar because, again, for very short intervals, that impacts the impingement on her nerves in her back, and that becomes somewhat excruciating. Contrary to that, Mr. is the one who, when they did make, again, it's modest. When they did make money, it was through his pottery. He purchased the kiln at about $2,500, other supplies for that endeavor. He made more money than she did. And again, I would certainly for today's hearing say that didn't amount to a whole heck of a lot. So we haven't included that, but we are requesting the $2,000 per month. From that, my client would make the house payment. She'll pay her car payment, which is $217. She'll pay the utilities on the house. And she'll also pay some of these credit card expenses. Again, relatively modest, but still a debt that she has that currently on her minimal Social Security she can't afford. Finally, we are asking for a award of attorney's fees and costs on a temporary basis. And we're asking for $2,500, and we're asking that any amount you require Mr. Myers to pay be paid within 60 days of entry of the temporary order.
Thank you, Mr. Zandy. This report.
Thank you, Your Honor. I'll try and be briefer. There's no dispute about vacating the homes. That's not an issue. As we said in our materials, my client's done that for the reasons he cited. So we're fine with an order that says she has temporary use of the home, and we can argue about separate community ownership at a later date as to that property. As to personal property, I agree with counsel. I'm hopeful that he and I can work out the details if needed for my client to get into the home to retrieve any more personal property. If we need to follow up on that via motion, I suppose we will. So otherwise, I feel confident we can do that. This, from our perspective, is simply a maintenance issue for temporary orders. We outlined in our materials the very specific amounts each party makes. And really the analysis is this: by the time my client pays the mortgage, which he's willing to do, and which, by the way, he does already automatically through auto pay through his account of $1,021, by the time he pays that mortgage and pays for his own living circumstance, because right now he's couch surfing because he doesn't have the money to do otherwise, he will have less money than she will pursuant to both their budgets. Because if you take out the 1,021, you take out a reasonable rent figure for him, which he's entitled to live somewhere, just as she's entitled to live in the house. That leaves him with about $1,200 a month to live on, leaves her $1,400 still to live on. So that's why we think that $1,000 figure payment of the mortgage basically on that house is a fair number under the circumstances, leaves them both, him with less money than her, quite frankly, to make ends meet based on the budgets presented. We acknowledge that she receives a disability payment, but they can't deny that there is a business and that she does make a little money. We provided you the sheet that shows items for sale, which suggests that there's money to be made. We concede it's not a large amount of money, but to the extent she has any, as counsel says, minor deficits in her spending, she can use that money to cover that. And even then, my client is in more of a deficit than she is based on their budgets and amounts. So we'd ask you adopt that $1,021 figure from my client's account toward the mortgage to continue through his account. Couple of collateral issues. We don't know about the credit cards. She managed the finances. So we'd ask the court at this juncture of the case to just require best efforts and not assign them to anybody because we don't know anything about them. We're going to figure that out via discovery. My client disputes or knowledge of anyways, any large credit card balance that now she claims basically as a way to offset or require more maintenance from him. This RV is an issue, Judge. Well, nobody wants the RV. It sits at wife's daughter's house, unoccupied, and it incurs a $400 a month payment. So my suggestion or request is that we sell it or do whatever we can to get rid of it because nobody's using it. My client certainly, their suggestion was he could live in it, but that's not something he's interested in doing. So we just assume get rid of the RV and have it sold. I believe it was in the process and something went sideways on that, but we'd like that back on. And then we'd like a directive from the court. My client wants to control solely his Fiber Federal account 5863. That's the account that the mortgage comes out of. Wife has historically kind of dipped in and out of that account. We want assurance that she won't do that anymore. This allows him to use that account going forward, prevents him from having to go redirect all of his money, Social Security and whatnot to different accounts. We'd like it all just kept through that account and her not to have access to it. His IRA is primarily his separate property incurred prior to marriage. We'll argue about that later as well. But my point is, it shouldn't just be a big pot for everyone to pull from during this temporary order period. He's going to need that money at a later date. And he stopped withdrawing from it until he gets a better idea of his finances. And finally, on fees, both parties retain counsel for similar amounts. There is no money. They're both retired, so they're both drawing on their separate funds. He doesn't have a pot of money to pay from other than his IRA, which at this juncture, given the circumstances, we'd ask that each party be responsible for their own fees. Thank you.
Thank you, Mr. Porter. Mr. Zandy, any comment on the RV being sold?
No, I'd have to run that by my client. It was our understanding when we filed this that that was where he was going to live as opposed to couch surfing. From my understanding, it's a nice RV. It does have that loan of approximately $400 associated with it per month. But I'll certainly ask her about that between now and presentation.
And any concerns related to control of the different fiber accounts?
Well, the issue with that is over the course of the past month and a half, it's my understanding he cut her off from access to that amount. And I think it's the fiber account. We're talking about the same one. It was down to about $160. He basically took that money, left my client with nothing. That was their in and out account that they operated from, paid the bills during the course of the relationship, which necessitated part of this motion until she's getting some kind of financial relief. I mean, she's got to pay the bills, and that was the account they did that from.
Real quick, Judge, that's not true. I'm not trying to argue with him. 5863 is my client's account that his Social Security goes into and the mortgage comes out of. They have a separate account at Fiber Federal that they're doing the in and out on. We just want control over that account related to his Social Security. That's all we're asking for because she goes into that account and transfers money around as too. So we want to make sure that doesn't happen.
Okay. All right.
And just one point on that, the 401k, the Empower 401k, that's kind of the variable right now that he can, that's a source of significant income. He can draw what he wants to from that. And I think the difference is in the numbers. There's the fact that he has now said, I'm not going to do that. My assumption is to reduce what it looks like as far as what he's taking every month when he can conceivably take $2,000 per month from that and be just fine.
Okay, thank you. Okay, so it sounds like the parties have agreed as far as the use of the home that, pardon me, the petitioner, Ms. Myers, will remain in the home and until otherwise ordered. It seems reasonable to me that if she's going to be staying in the home, that she have that right to privacy, just like she wouldn't be able to kind of barge in on where Mr. Myers is staying. The reverse would be true also. So I'll allow and order that Mr. Myers does not have access to the home unless there's express agreement between both counsel. The issue of maintenance, it's a 17-year marriage. We look at the need of Ms. Myers. Her income is modest. It's a disability payment. And we look at the ability of the other party, Mr. Myers, the respondent, to pay. His income is slightly higher than hers, about $3,700 a month compared to her $1,400. He does have potential for additional income through the Empower IRA to the tune of around $400,000 at this point. So I'm going to award $1,200 per month of spousal maintenance from Mr. Myers to Ms. Myers. That puts them in rough parity. Of course, Ms. Myers will have to spend a bulk of that for housing, and she would be required to pay the housing. We'll just shift that burden to her to pay the housing, the mortgage, 2021. As far as the credit cards, I don't have a really clear idea of the credit cards. There's been a listing of cards and the monthly dollar amount and outstanding balances and who got them, but I'm just not completely sure on those. So I'm going to do best efforts to pay those at this point. And attorney fees, I'll award $1,500 from Mr. Myers to Ms. Myers for the attorney fees. And as far as the control of the different bank accounts, that seems like a really good idea to me at this time, that there be separation of bank accounts and each party have control of their own account. Here, the 5863 account as indicated by Mr. Myers as being his account. He'd like to have control of that. And Ms. Myers is represented by him that her account number ended in 3704 with the award of spousal maintenance. I don't see much need for either party to be having access to the other accounts. So those accounts will be in the control of each of those parties. And steps, I guess, would need to be taken if they're, joint accounts or to have somebody removed or what have you, that there need to be joint cooperation to make that happen.
And a start date, Judge, for the order. It looks like this was filed back in September. Due to nobody's fault, last week we got kicked over due to court congestion. October 1st.
Mr. Brewer, do you have a suggestion?
Well, I'm not opposed to that date. I mean, remember, we've already made the mortgage payment for October, so I guess it'd be the differential due in October. And then I would also suggest, I think the mortgage payment's going to come out here any day, so maybe same thing, and then the parties can work on switching things around to be effective. So she starts making the payment December 1st. Council and I can hopefully work through those details.
Okay. Let's have the start date October 15th as far as the maintenance support, and the 15th of each month thereafter.
And presentation.
Do you want to look at the 14th?
That's fine.
And then as far as that consolidation, would somebody be able to just draft up a brief consolidation order?
I can do that.
That's kind of good. Thank you. All right. If there's no other issues, that'll conclude that hearing. Appreciate everybody's help. Thank you.
Thank you.
Thank you,
Council.
All right. And that looks like that concludes the docket. So I'll go ahead and end the call now. Thank you.